No, come on Monday.
My lord,
Yesterday I've taken up all
my
matters.
lord, with your lordship's kind leave, my lord, I am compelled to mention a very urgent motion, my lord. What has happened, my lord? The petitioner had been allotted a parking lot by the Eastern Railways. It was a 3-year contract, my lord. He had applied for renewal, which is entitled to under the clause of the deed. But without considering his application for renewal, the authorities have issued a notice of fresh tender, which is going to be held on 8th of January, my lord.
So,
My
what
lord,
can be
kindly
done?
take
You
it to
think
heart,
it is
my
your right? Can you claim it as a matter of right?
My lord, I shall satisfy your lordship. The clause 7, there is a clause 7 in the deed.
Whatever
where
is
he
there is there.
entitled, my lord. He is entitled to apply for renewal. Let his application be considered, my lord. They are issuing a fresh tender on 8th of January, my lord. Kindly appreciate.
7th, your matter will appear. Where is it?
Well,
Where is it?
it is appearing in the combined list, my lord.
Item number.
May I have your lordship?
Put your item number over there and hand over the slip. Put it up in the urgent motion bundle.
I have your lordship kindly to mention, my lord, one matter which is going to expire. My tender is going to expire on, I am working on extension on 5th of January, on 6th of January. 31st December was the time allotted for my tender, which was doing for sweeping and for cleaning purposes of the railway racks and for the railway different coaches, my lord. On 31st December, my tender has expired and they were awarded to somebody by floating a new tender by giving a quotation of 46 crore and they have awarded to somebody 38 crore. My work is under extension, which is going to expire on 6th. With a short service, my lord, I want to move this petition on 6th because my extension period is still 6th of January, and I am working on a very without getting my remuneration, which has already.
No, all said and done. If the authority goes for a new tender, where is the difficulty?
Tender has already been allotted to him.
Yes, so where is the difficulty?
My lord, because it was allotted, the fixed rate was 48 crores, but they have allotted to somebody who has quoted 39 crores, and I am already working at 43 crores. And how they have been
They
giving
cannot, can't the authorities accept a tenderer with a lower value?
unskilled workers, if it is calculated with application of the GST also, it will come to 43
I do not know what the GST
Well,
calculation.
778
The authority has thought it fit.
That was the central government rules, current rules as per 2024 notification is the minimum wages that is to be given to the unskilled worker. That is also 778. If it is calculated for 427 workers also, it will come to 39 crores and odd, and including GST.
Even then, you do not come in the fray.
Yes, I am coming within 43 crores. The quoted tender was for 46 crores and they have quoted at 38 crores and I am working at 43 crores. I have given the lowest bid. And my 5th I have come to, and on 3rd I have come to learn, my lord, I have prepared the writ petition. I am just praying for short service and to move it on 6th.
Very well, it will appear on 6th. Serve the Union of India is a party? Is the Union of
Eastern Railway.
Ensure presence, serve.
Yes, my lord.
My lord,
Grant that leave.
my lord, may I have your lordship?
Monday as urgent motion.
May I have your lordship's kind leave to mention, because this is regarding item number 308 of your lordship's daily list. The urgency is this, my lord. The tender has been given and the HBN bidder has been declared by the PWD authority.
Why did you not come yesterday? I accepted all slips.
My lord, actually,
the upgradations I accepted.
Yesterday, my lord, before Justice Sengupta, we have a
Whoever.
fixed matter at the first stage, at the very first attempt. Kindly appreciate the urgency, may I? Because the HB1 H1 bidder who has been declared as the highest bidder, he is already blacklisted by the National Highway Authority in spite of representation made by the petitioner, who is also one of the intending bidder. The authority has given that person who is already debarring from participate in any tender proceedings. So, my lord, the urgency is this second. In spite of that, the highest bidder has not be able to put the tender money, which has been extended by 2 days by the authority and which will be coming to an end by tomorrow. So, if your lordship kindly take up this matter today or Monday, as your lordship kindly.
Well, Monday you give the number.
Your lordship.
And serve.
Already you have served, my lord.
Fresh notice to be given so that your other side is there.
Lordship. Deeply obliged, your lordship.
Urgent motion.
308, my lord.
Come on Monday, please.
My lord, may I wait, Korun? May I be permitted to be mentioning extension of interim order, my lord?
When is it expiring?
10th January 2025.
Give.
Lordship.
Lordship, I'm praying for leave to file and move an urgent application, Your Lordship. The electricity connection has been disconnected without a disconnection notice under Section 56. Hearing was continuing in the Ombudsman. The Ombudsman directed to pay an ad hoc amount. That was paid. Despite that, no bill was regenerated and it has been disconnected, Your Lordship. The connection is for a submersible pump, Your Lordship. I'm ready to move on any day, Your Lordship, as Your Lordship directs, Your Lordship. It's extremely urgent, Your Lordship.
Tuesday, it will appear as urgent motion, serve notice.
Grateful.
Tuesday,
My lord, this is contempt application for inclusion.
come on Monday, please.
Lordship, I had mentioned a matter yesterday, whereafter it was correctly pointed out by this bench that since it relates to CLAT 2025 examinations, it will fall under Group 2. Therefore, kindly leave liberty be provided by your Lordship to make the appropriate corrections and move it before the appropriate.
Where is the matter now?
Lordship, it was moved. It had been moved before the vacation bench, and thereafter.
Is the matter here?
Yes, your Lordship.
Where in the list? Is it
Lordship.
there in the list?
Lordship, I don't know exactly which item number it is.
You are mentioning a matter without knowing the item number?
Lordship, it was put under Group 9. It was our mistake. It was put under Group 9.
If the file is here,
Yes, your
you can take it, mention it before the appropriate bench. Let the requisition come if the file is here. Otherwise, send the requisition. Since the matter is not listed, you can always take steps.
Lordship.
All right.
Lordship.
Lordship, may I permit to mention a matter, Lordship? Circuit bench, Jalpaiguri matter, Lordship. My matter was disposed of on 4th October 2024, Lordship. My that order is not uploaded in the server copy as well as Lordship original file, Lordship. File lying is here, Lordship. Super my instance.
How can the Jalpaiguri file come over here?
My Lord, earlier question I have mentioned this matter on virtual mode, Lordship.
Yes, for what? Correction?
No, Lordship, my order the matter was disposed of, Lordship.
If the matter is disposed of, why will the file come here? The file will not come here. DP বাবু জলপাইগুড়ির মামলা তো একটু দেখুন না একটু কি হয়। Done. প্রদীপকে আমার সাথে একটু কথা বলতে বলুন।
Lordship, praying for upgradation of item.
Come on Monday. Yes.
May I please be allowed to mention the matter, my lord? The petitioner is working as a
What do you want?
under the direction of Honorable Justice Joyshen Gupta.
What do you want?
The petitioner wants to apply for an application for arms license before DM. Without showing any proper ground, the
Listen,
DM has
when you
dismissed
are
the matter.
mentioning, you are to tell the court whether you want inclusion, upgradation, urgent motion, something. I do not want to know the merits of the matter at this stage. You are mentioning now. If I hear mentioning the merits at the mentioning stage, then the whole day will go. So what you want?
Inclusion, my lord.
Inclusion in the list? Come on Monday. বলুন।
My lord, read petition 30852.
আপনার উকিল বাবু আছে?
আমি ইন পার্সন
হ্যাঁ।
তো মামলাটা ফাইল করেছি। ফাইলের সময় আমার মনে হয়েছিল এটার ভুল আছে, মানে কস্ট টাইটেলে দুজনকে অলরেডি সার্ভিস হয়ে গেছে। তো আমি কমিশনারকে বললাম যে এখানে আমি একটু হাতে লিখে আমি সাইন করে দিচ্ছি। বলুন না আপনার সিল টিল পড়ে গেছে, কোর্ট ফি পড়ে গেছে, এটা করা যাবে না। তখন আমি বললাম দেখুন এটা করা আছে। তখন ওখানে যারা ছিলেন আর কি কোর্ট ক্লার্ক বললো একটু দেখতে। তো উনি করলেন কি থার্ড যেটা মানে স্টেট অফ ওয়েস্ট বেঙ্গল যেটা হবে সেটা বললেন গভর্নমেন্ট প্লিডার করে দেন। তো আমি বললাম যে গভর্নমেন্ট প্লিডার তো পার্টি হয় না, স্টেট অফ ওয়েস্ট বেঙ্গল দিয়ে ঠিকানাটা লিখিয়ে আমি আর বলতে পারবো না। আপনি গভর্নমেন্ট প্লিডার যদি লেখেন তাহলে আমিই করবো। এবার গভর্নমেন্ট প্লিডার লেখা হলো, মামলা ফাইল হয়ে গেল।
শুনুন, ওখানে যারা বসে আছেন তারা তো আর উকিল বাবু নন, তারা আপনাকে অ্যাডভাইস করতে পারবেন না। আপনার যদি কিছু জানার থাকে আপনি কোনো উকিল বাবুর সাথে যোগাযোগ করুন, তিনি আপনাকে সাহায্য করতে পারবেন।
আমি একটু কস্ট টাইটেলটা আমার হয়ে গেছে, সার্ভিসও কমপ্লিট, 6 তারিখে মামলাটা লিস্টে আসার কথা। যদি একটু কস্ট টাইটেলটার জন্য আমাকে একটু লিভ দেন, আমি একটু করে দিতে পারি।
লিভ তো এইরকম ভাবে দেওয়া যাবে না, লিভ এইরকম ভাবে দেওয়া যায় না। যদি 6 তারিখে মামলা লিস্টে আসার থাকে, মামলা লিস্টে আসবে, যখন ডাক হবে তখন আপনি বলবেন।
সার্ভিসটা করতে পারছি না আর কি, শুধু সবাই হয়ে গেছে, শুধু গভর্নমেন্ট লিডারকে আমি এটা দিতে পারছি না। কালকে গিয়েছিলাম, অনিল বর্মা বললেন যে আপনি তাহলে লিভ নিন। আমি লিভ আমি নেব, নিয়ে আপনাকে সার্ভিস আমি।
লিভ এইরকম ভাবে দেওয়া যাবে না। কল দ্য লিস্ট।
Lordship, kindly consider tomorrow.
Item number 1, my lord, I appear for the applicant in this matter. Now, my lord, on the last occasion, my lord, you have directed the contempt, my lord, to make a payment of rupees 25 lakhs, my lord, for alternative accommodation. That payment has not been made yet. And my lord had indicated in the last order, my lord, that
Government is free accommodation.
Your clients are not willing to stay in the government shelter home?
no, we are willing to stay in the government shelter home, but my lord, the list that has been provided by the government of West Bengal, it appears, my lord, these are NGOs and these are paid accommodation.
Paid accommodation?
I have checked up in the Red Cross place. One accommodation is there. They say, my lord, it is paid and they don't have the vacancy right now.
Paid?
It is paid and it doesn't have the vacancy also.
Doesn't have a vacancy. Then you have to make a arrangement for yourself.
Yes. But my lord, the amount is determined
What
by your
about
lordship.
payment? Division bench directed payment of
25
25 lakh? Yes.
My lord, payment, my lord, your lordship's order, my lord, I have seen, my lord. My client is, my lord, cannot, my lord, pay the, my lord, 25 lakhs rupees. Because, my lord, he, my lord, the Rapido driver, my lord, he drives Rapido, my lord. He has no other income.
Very well. In that case, he has to be taken in custody. Otherwise, there is no other alternative.
My lord, I have seen the, my lord, entire order, my lord, the order of your lordship, my lord. I have
No, not my order. It's a division bench's order.
I may be, my lord, filed my affidavit, my lord.
For what? For what purpose?
My lord, your lordship kindly appreciate in the content matter. I was not given an opportunity to file my affidavit. That I have not violated your lordship's order. That, my lord, that I can at least, my lord, file my lord affidavit, my lord. My lord, even, my lord, the rule has not been yet issued. I am appealing, my contemner is present also, my lord.
No, that
Your
is
lordship,
something
my lord,
different. You want the rule to be issued and I'll direct.
I need, my lord, at least the affidavit that should be on record, my lord. There is no affidavit on record that I have not violated your lordship's order.
No, you have violated. There is no question of non-violation.
Violation, my lord, that there must be a willful and deliberate.
Yes, I find it to be willful and deliberate.
My lord, willful violation, my humble submission before your lordship.
You want to file affidavit? I'll give you a chance. Please come.
My lord, I need, my lord, your lordship only record my submission that I need.
I'll not record anything you say, whatever you want to say in your affidavit.
My lord.
Learned advocate representing the contemner seeks time to file affidavit in the matter. Stop. What about the corporation?
Yes, ma'am. I'm corporate.
Yes. Has the building been brought down?
Yes,
Degi? This is already on record. এটা তো already record হয়ে যাচ্ছে, এটা দরকার নেই। ঠিক আছে। Are your clients still there?
Yes, the last occasion where it was submitted, my lord, the lordship had directed the state authorities to file a fresh report, my lord.
Yes.
Lord, on oral instruction, my lord, I have taken from the officer in charge. There is no such a free accommodation or old age home. All run by NGOs.
All run by NGOs and paid accommodations. File affidavit বললাম তো? আচ্ছা, on such prayer, let affidavit in the contempt application be prepared and circulated by 17th January. List the matter on 28th of January. Exception may be filed prior to the adjourned date. Stop. Paragraph. Learned advocate for the state submits that there is no free accommodation available for the welfare homes, and the welfare homes of the state are run by the NGO and they are paid accommodations. Stop. Paragraph. The applicants will be required to make their own arrangements. Stop. The List on 28th.
I am deeply obliged.
My lord, in this matter, my lord, Mr.
Lord, I am appearing for the petitioner. If you're
As the contemner is reported to be personally present in court, accordingly, issuance of contempt rule stands dispensed with.
Well, before my learned friend starts,
My lord,
I
Mr.
have to
Vishnu Chaudhary is appearing in this
Milord,
matter.
I am there. Milord, I am there.
yes,
Petitioner,
Yes, Milord.
you are for the
I am for the respondent bank.
bank.
But today I am a bit handicapped. I have been
Alright.
briefed today in the morning. My advocate on record is unwell. But today kindly accommodates me if my learned senior.
No, I have no problem, Milord. My learned, I don't want.
Monday, Tuesday, any day.
Not
Any
today
day.
only.
Lordship, I am also
Grateful.
appearing on behalf of the respondents.
Which respondent?
The respondent bank, Your Lordship.
She is along with me.
With you? All right.
Grateful.
I'm led by Mr. Dotto.
Yes.
Grateful, Milord.
I'm grateful.
Milord, I beg to appear for the petitioner.
I'm for the private respondent.
State is to answer, my lord. My learned friend is appearing for state, my lord. Here, my lord, the case of the petitioner is this, my lord. Property has been purchased. For purchasing, my lord, I had not put in the set for value, which is the highest value at 87 lakhs. When a query was obtained, my lord, the valuation was shown by the department as 1 crore 54 lakhs. We challenge that by way of our representation, saying that this is a very low land and not well connected. It cannot be 1.54 lakhs. So under the statute, under 47, I have a right of preferring an appeal. Now, the difficulty is, my lord, the rule has been introduced, 124, which says that I have to deposit the entire stamp duty, pay the entire stamp duty, and the receipt I have to give with the deed for presentation of the deed. So, 147 is a right of appeal, but
At the same time, upon payment of money,
upon
that
payment
has
of
to-
entire money,
All right.
if I pay the money, the rule 47A says that if I pay on the deposit on set for value, I don't pay the money, then it shall be sent for appeal. So, on one hand, they're giving the right in the statute, rule is taking it away.
Are you challenging the virus of?
No, I have not challenged the virus. There are several orders of this honorable court where virus is under challenge. Court has directed deposit the deed, let it be sent for adjudication. There are several orders. There are 2 orders I have given. I have not presented the deed. In this case, my case is better. I have paid the stamp duty, but my prayer for adjudication is pending before them. I have paid the stamp duty. Let them send it for adjudication. Here, my lord, they have not paid the stamp duty in these cases. Copy
This shall not be treated as a precedent.
But
in
the next
other
matter, my lord, same thing was followed. Kindly see the next order, my lord. This was followed in another matter.
The matter is fixed for further hearing 1 week after the vacation. Right.
Yes.
And was any direction given for filing affidavit? Nothing
the
of
next
this
page,
sort.
no, that matter is still pending. Next matter, next page, my lord, the order of tri-wave infracom. Here also, my lord, the same thing was followed.
Yeah,
In
the
both
virus
cases,
is under challenge.
yes, virus is under challenge. Both cases, stamp duty was not paid and the deed was presented. I am saying I'm not challenging 124, rule 124. I am paying the amount, but I have a right of appeal under 47A. So my prayer is that let my appeal be considered by them. I presented the deed. Since I have paid the stamp duty, they will not send it for appeal unless my lord, your lordship directs. This is the only thing I am praying. Let them consider it.
Instruction as of not today. May I come back with the instruction?
When?
Next week.
Next week means today is Friday. Next week starts from Monday.
Wednesday or Thursday.
Wednesday?
Wednesday or Thursday. Friday. Let it be Friday, my lord.
Next Friday?
Next Friday, my lord.
All right. The petitioner prays for a direction upon the registering authority to adjudicate the stamp duty in respect of the document which has already been presented before the said authority in accordance with the provision of section 47 cap say of the Indian Stamp Act, 1899. Stop. The petitioner relies upon the order dated 17th August 2017, passed by a coordinate bench in WP number. In the matter of such and such, and the order dated 8th April 2019 in WP number, matter of such and such. Learned advocate representing the state respondents seeks time to take instruction in the matter. Stop.
I am restricting my prayer to prayers D and E only, my lord.
List the writ petition on 10th January. You appeared for the state in one of
In
the
that
matters.
matter. Those matters are pending. So I am not challenging the Vaida. I am only, my lord, saying that I also should have a right of, my lord, adjudication. That's all.
Yes.
I am restricting to prayers D and E. No, nothing else. Affidavit of service, my lord.
Affidavit of service.
So I am for the writ petitioners. My lord, this is a challenge to my lord, registration, my lord, which has been done, my lord, under the West Bengal Apartment Ownership Act, my lord, of 1972. My lord, there is, my lord, a statutory registration, my lord, under the Act. My lord, it requires, my lord, certain procedures to be followed. 2 or 3, my lord. First, my lord, because, my lord, it requires that, my lord, whatever is, my lord, put into, my lord, the registration, my lord, certificate, and, my lord, with regard to, my lord, common areas and all that, my lord, it's binding on, my lord, all, my lord, the owners.
1 minute. The state is represented.
Yes, my lord.
Competent authority under the West Bengal Apartment Ownership Act is also there.
327.
327. Yes.
My lord, I am appearing, my lord, for some of the owners. My lord, our grievances, my lord, twofold. One, my lord, that
Owners of that apartment.
yes, my lord, we own, my lord, about 40% of, my lord, the area of, my lord, that apartment. It's an apartment, my lord, block. So, my lord, I own, my lord, about, my lord, 4 flats. And, my lord, the area also, my lord, comes to, my lord, about 30% of the area. My lord, the Act requires, and, my lord, it's a very strict interpretation, my lord, which has been given by our courts, my lord. The Act requires, my lord, a notice to everyone. It requires, my lord, a form, my lord, to be submitted and, my lord, consented by everyone, my lord, for the purpose of registration. And most importantly, it also, my lord, has a time period of, my lord, 3 years from the date of completion. My lord, I'll just give a copy of the Act, my lord, kindly. The registration, my lord, will find, my lord, under section 10. Let's sorry, my lord. First, kindly, my lord, come to, my lord, section 2. Sorry, my lord, section 2 first. This Act shall apply to every property, every residential units of both residential and commercial units, and the sole owner or all the owners or majority of owners of every such property shall submit the same within such period as may be prescribed to the provisions of this Act by duly executing and registering a declaration setting out the petition particulars referred to in section 10. Now, my lord, kindly come to, my lord, section 10. Section 10, my lord. The declaration referred to in section 2 shall be submitted in such form, accompanied by such fees, and in such manner as may be prescribed, and shall contain the following particulars, namely description of the property, name of the owner, nature of interest of the owner or owners in the property, existing encumbrance, if any, description of each apartment containing its location, actual built up area, description of, my lord. E becomes very important because, my lord, quite naturally, my lord, there's a dispute here, my lord, between the owners and, my lord, another set of owners, my lord, who's gone ahead, my lord, and had it registered, my lord, behind, my lord, our back. Description of the limited facility, all this, my lord, description have to be given. Then, my lord, 10A is very important. Lord, sees any declaration referred to in section 2 or any amendment thereto or any instrument referred to in subsection 3 of section 4 shall in the first instance be submitted by the sole owner or all the owners or the majority of the owners of the apartments in duplicate.
My lord, here, my lord, I'll show, my lord, one of the caretakers, my lord, who has no interest, my lord, has really, my lord, submitted within 30 days from the date of his execution to the competent authority, along with copies of site plans, building plans, notice of intention to submit the property to the provisions of this act by the majority of owners specified in section 2 to the remaining owners of the property in such form as may be prescribed. When such declaration made by majority of owners, remaining owners shall be allowed to submit declarations subsequently either individually or collectively in such form as being prescribed. Then, my lord, 2, on receipt of a declaration or amendment thereto, or an instrument referred to in subsection 1, the competent authority shall, after issuing notice to the parties concerned and after holding such inquiry, if any, as it may consider necessary for the purpose, examine the declaration, the amendment, or the instrument as the case may be, to ascertain whether the property concerned comes within the purview of this act. Declaration, the amendment, or the instrument is in order. Then by an order in writing, give reasons thereof, accept or reject the declaration, the amendment, or the instrument, and in case of acceptance, immediately return the declaration, amendment of the instrument, along with all enclosures to the owner or owners, as the case may be, for registration within 120 days of the date of return. Case of rejection, forthwith communicate the order of rejection to the owner or owners. So, there's a detailed procedure, section 2, followed with the declaration under section 10, because it becomes binding with regard to dispute with regard to common areas. That's the purpose of the act, it seems. Then 10A has this notice to the remaining owners as well, which is us. Then kindly come to the rules, which should be immediately after that. After section 18, we'll find the rules. West Bengal apartment ownership rules. It may be flagged,
Yes, yes. Yes.
Rule 2A.
Yes.
Period of submission of Form A. The sole owner or all the owners or majority of the owners of the every property shall submit his or their property within 3 years from the date of completion certificate issued by the competent authority. And this has been held to be mandatory. We have judgments to that effect. And here the completion certificate was 1998. So far as this building is concerned, I'll just give just 2-3 factual dates. 1998 is the completion. Then 2012, there was an informal association which was formed, and the developers were collective maintenance. There is a civil suit which has been filed with regard to dispute between the owners. And after writ of summons was served, they registered it in 2024. The respondents, respondents 4 to 7. And 7 who submitted is really a caretaker. He has no interest in the property. And Form A not served on us. And Form E, we could not find it's there at all. So Rule 2A, and will also kindly see Rule 3. In fact, we had a series of cases. Unfortunately, where it seems the competent authority drop our hat without following any procedure. Because we were involved in some without any procedure. They go and register it at the instance of some of the owners, and particularly where there's a dispute with regard to common areas. What is really the common area, not area? All that they go and register it.
But the common areas are registered as common areas.
If there's a dispute with regard to common areas, what's happening? Not in all matters. If there's a dispute, when someone registers it, that becomes sacrosanct. I've seen how things are bypassed. You have a dispute, you go and register it behind someone's back.
Yes.
And therefore, you give it a statutory flavor. Then Rule 3. The form and manner in which the declaration referred to in Section 2.1 or Section 10 and Section 10A shall be submitted to the competent authority. The declaration under Section 2 by the sole owner, all the owners or majority of owners, as the case may be, of a property, shall be executed in Form A and be signed, this is very important, and verified by the sole owners, all the owners or majority of owners, as the case may be, in presence of magistrate or any other person competent to administer oath. In case where majority of owners intend to submit declaration under Section 2 in Form A, they shall give notice of their such intention to all the remaining owners in Form E. 2. After such declaration signed and verified as aforesaid, same shall in strict conformity with the provisions of subsection 1 of Section 10A be submitted to the competent authority. When on receipt of such declaration, competent authority, after following the procedure laid down in clauses A of subsection 2 of Section 10A, records an order under clause B of subsection 2 of Section 10A, accepting the declaration, it shall make an endorsement on the body of the declaration, testifying the facts of the acceptance of declaration, put its date, signature, and set its seal. Thereafter, when in terms of clause C of subsection 2 of section 10A, the competent returns the declaration along with its enclosure to the declarant or all the declarants as the case may be. Such declarant or declarant shall within 20 days from the date of such registration present the declaration registration under the Registration Act at the office of the registrar in jurisdiction. In case where declaration submitted by majority owners accepted by the competent authority, remaining owners shall, if they like, be allowed to submit declarations as shall be executed in Form D. Then, my lord, this, my lord, is the procedure. Now, my lord, kindly look at, my lord, our writ petition. My lord, what is under challenge, my lord, is at, my lord, page 80. Page 80 is, my lord, they register themselves, my lord, this, and 81 are, my lord, the certificate, my lord, will find, my lord, on 7th February 2024. And, my lord, the declaration which is there, my lord, is at page 87. This is Form A. My lord, we may never serve, my lord, we have a certified copy, my lord, of this.
Without annex. Certificate form A is missing.
Page 87, my lord, very interesting. My lord, executed Sri Bapi Lohar. My lord, he is respondent number 7. And, my lord, so far as, my lord, we are aware, and that's the averment, my lord, he is, my lord, the caretaker, my lord, of the property and not any of the owners. 89, my lord, will 92, my lord, will find. My lord, kindly see 92. This is a copy of relevant. I'm sorry, my lord, the third paragraph. Second paragraph. Authenticated copies of building plan, site plan prepared by Mukul Mitro, architect, sanctioned, appended as Annexure A and B. Copy of relevant completion also appended herewith, marked as Annexure C. Copies of voter card, Annexure D collectively. We don't have, my lord, all these annexures because, my lord, we only got then copies of receipt of letter in form E served to all the apartment owners.
You said this was never served?
No. That's, my lord, case. And, my lord, at page 100, my lord, will find. My lord, kindly see, my lord, page 100. He signs, my lord, this gentleman Lohar. He signs, my lord, on behalf of, my lord, the 7
All
flats.
All of them.
No, my lord, we are, my lord,
No,
5.
page 100, 1 to 7, he signs for all.
Yes, correct. All, my lord, all the owners.
Apartment owner's name.
And, my lord, our flats, my lord, will find, I'm sorry, my lord, page 97.
Yes.
We are, my lord, flat number, 5A. 5A. 5B, 1A and GC, 1C.
5B is in the first.
13, my lord, at the bottom, my lord, will find.
13, 5B.
Oh, my lord, sorry, yes, my lord is absolutely correct. Yes, at the top, page 97 or top also, my lord, those 3 are there, correct. Yes. My lord is correct. Absolutely.
The third row,
Yes.
5B.
5B.
From the top.
From the top.
From the bottom, the last row,
Yes.
second column is 5B.
Absolutely.
Apartment.
So we are 5B, 1A.
Location. 5B, 1A.
And
yes.
GC, 1C.
GC, 1C. From the top, I get it.
And those are all of the writ petitioners here. Great Wall, Circular Synthetics. and GC 1C are two companies 3 and 4, P3 and P4. Now kindly look at, so this is the case we come with, and has seen and now kindly look at what has been decided. Fortune first is Arna Johnson. And here
what is your prayer in the writ petition?
It is presently for stay of operation of the effect of this certificate immediately, because what they are doing on the basis of the registration, they are holding apartment owners meeting. It's a non-starter. You couldn't have it registered. There's a meeting tomorrow.
But then tell me.
Yes,
this registration took place in January 24.
February 24.
February. The
Yes.
first document is January, then is the February. The
Correct.
certificate is issued. What were you doing for the last 1 year?
In May, representation several May.
We came to know in May. We have stated that in the writ petition. We have also made a representation to them. Page 56. Page 56. Will find our representation. Page 56. Then 57. RTI.
Right to RTI 109.
Kindly look at page 56.
Yes. 21st of May.
17 May. 17 May, first page 56.
Yes, received on 21st.
Yes. Correct. Absolutely, I'm grateful.
Hmm.
Then RTI also on
Page 57.
page 57.
Right.
And then reply is at page 109. And you see the information which is RTI which is given.
Yes.
2nd August.
Right.
Not available.
Which reference reforms are not available in this office. All right.
Then next notice to the authorities. Page 110.
And for the last 1 year, wasn't any meeting held?
We won't.
You were not intimated or
Yes.
informed, but then the meetings were held possibly for the last 1 year.
From registration is February 24. I don't know, we don't have that information to say whether, because we were complaining with regard to this registration because it could not have been done. I'll just show the judgment. It's a non-starter. Rule 2A says 3 years from the date of completion. Here completion is 1998. Just kindly have a look at this one decision.
Is there any default clause if somebody does not register it within 3 years?
No.
Then what happens?
Then you form an association which is outside the scope of the West Bengal Ownership Association. Absolutely correct. There's no default, but then you have to form it outside. Then you can't come under the Apartment Ownership Act. If you register it within 3 years, then it has a statutory flavor in terms of this. Because then you're binding everyone with whatever the declaration is in section 10. So that is why, and this point was also raised, when we raised the point with regard to that, there's a limitation of 3 years. The court held that correct. Yes, this has to be mandatory because 3 years is enough time. So if you don't register, then you don't come within the scope of this act. Because what has seen several apartments where they have this first initially the developer comes, takes maintenance, and then they form an association. It's a headache for everyone. But that's what happens. Kindly just have a look at this. Paragraph one will find
The challenge.
yes, that's the challenge. Then 2 is again with regard to no notice. Then the arguments are considered. And then kindly look at 5, paragraph 5, the last line. Rule 2A of the West Bengal Apartment Ownership Rules 1974 stipulates 3 years as limitation period for doing so. That's the same. A very exercise was time barred. Then, my lord, straight away kindly come to my lord, paragraph 7 also, my lord, can just have a look, my lord, very cursorily, my lord. On merit, several disagreements sought to be pointed by the petitioners. Further, it is argued that within the contemplation of section 2, read with section 10 of the Act, the sole owner major had to apply for registration. Present case, one Mukesh solely applied as evident from the application annexed, page 70 writ petition, although admittedly there are several owners. Although a power of attorney has been sought to be relied on by the said Mukulesh, same is not reflected in the form a declaration. Then, my lord, kindly come to paragraph 21. Paragraph 20, my lord, Fortune Park House, my lord, I want to also rely on that judgment because the argument made was you don't have to give notice to all the owners. That was, my lord, rejected. Then 21. Secondly, Rule 2A of the 1974 rule uses the expression shall to qualify the requirement of submission of the property. Such date commences from the completion certificate being issued by the competent authority, which in the present admittedly happened in the year 2011. Rule 2A is not in derogation of the parent statute, but in furtherance of Section 2 of the 1972 Act. Section 2 provides that the Act shall apply to every property having residential units of both residential and commercial units, and the sole owner or all the owners or majority owners of every property shall submit the same within such period as may be prescribed. Mulad will recall, Mulad, that language there. By duly executing and registering a declaration, setting out the particulars referred to in Section 10. Thus, the period within which the declaration has to be made and registration is to be in terms of Section 2 as per prescription. Section 3J defines prescribed to mean prescribed by rules made under the Act. That the 1974 rules in Rule 2A embody the limitation period which is applicable to any application under Section 2. Respondents have sought to argue by placing reliance on the preamble of the Act that the intention of legislation to include apartments within the fold of the Act, not to exclude the same. Further argued, statute does not provide any consequence of delay beyond 3 years, no negative language used. However, such arguments adhere the provisions of the Act, rules determine. Then, number 27. Both Section 2 and Rule 2A of the 1972 Act and the 1974 rules respectively use the expression shall. Mere omission to stipulate a consequence for non-adherence to the limitation period does not alter the mandatory character of such provisions. The argument on the preamble of the Act is vague, since the preamble merely states that the Act is to provide for the ownership of an individual apartment and to make such apartment heritable and transferred property. Assuming that the provisions of the Act are not invoked in case of particular apartment, the general, this is perhaps not what the general law as applicable to properties and apartments shall very well be applicable. The law leaves no void on such aspect of the matter. In fact, Section 2 leaves no manner of doubt, as it has been conferred the discretion on the apartment owners themselves to choose whether to subject themselves to the provisions of the Act or not. Very stipulation that the Act shall apply only to properties regarding which owners submit the declaration as stipulated in Section 2, by necessary implication also confers the option on the apartment owners not to make such declaration, thereby preferring to remain outside the purview of the Act. Option cannot be an open-ended window left open forever. A sufficiently reasonable time of 3 years from issuance of the completion certificate has been given by Rule 2A for the apartment owners to seek registration by submission of a declaration. Having not done so for the inordinately long period of 13 years from 2011, when the completion certificate was issued, till 2024, when the declaration was made, it is expressly evident declaration sought by the private respondents time-barred. Thus, the acceptance of such time-barred declaration and direction to register same is also vitiated on such count. Then, my lord, paragraph 31, my lord, perhaps, my lord, we can skip over. And, my lord, 33. Lastly, Section 10A read with Section 2 of the 1972 Act contemplates 3 categories of persons eligible to make the declaration question. If there's only one owner, sole owner shall apply. On the other hand, all the owners, if there are several, may also apply. Question of majority applies comes only when there are more than one owner of the property, and all of them do not choose to make the declaration together. In such case, the law contemplates that the majority owners to make the application annexed to the pleading show only one Mukesh having son such, made affidavit is sought, contents are such. Then, my lord, they are the learned, my lord, our courts, my lord. 34, respondents could not dispel the obvious discrepancy. Then 36. Thus, WPO number 73 of 2020 allowed on contest, thereby setting aside the order accepting the declaration submitted allegedly on behalf of private respondents purportedly under Section 10 of the 1972 Act, and all consequential action taken pursuant thereto. Order accepting the declaration, the subsequent registration, or other action, if any, taken consequent, are hereby set aside and quashed. And, my lord, just, my lord, I'm so sorry, my lord, if I can just trouble my lord with one more decision. This is, my lord, Fortune Park, which was, my lord, considered. This is, my lord, with regard to, and that is, my lord, clear. the requirement under section 10A for the hearing. My lord, paragraph 2, my lord, will find, my lord, without prior notice. And I don't know whether my learned friend, my lord, also, my lord, would like to, because this was also considered, my lord, on the question of alternate remedy, because, my lord, there's no other, my lord, provision, my lord, which is there. Then, my lord, kindly come to paragraph 14. Upon a perusal of the materials on record, transpired that there is nothing on record or apparent from the submission of the parties to indicate any notice was given by the petitioners developed at any point of time under section 10(2)A of the 1972 Act. Then this is, my lord, the argument made by the competent authority. Kindly see, my lord, insofar as the submission of the competent authority is concerned, to the effect that parties concerned contemplate in subsection 2A only speak about the applicants themselves. That's not the purpose of the Act. The same would be an absurd interpretation, cannot be accepted, would be something like issuing a summons to the plaintiff himself. Obviously, within the contemplation of the inquiry as envisaged in section 10A, 1 read in conjunction with the notice under 10A2A, notice has to be issued not to the applicant alone, as is evident from the language of said provisions, but to the parties concerned. The said expression immediately suffixed by the phrase after holding such inquiry. Hence, it is clear that all parties were affected by such registration or acceptance of the declaration, and the form A are required to be given notice prior to deciding on the same. In the present case, since such notice has not been given to the petitioners, petition justified in arguing that the acceptance of declaration in form A and registration of association itself is perverse. Then, my lord, 18 deals with, my lord, the non-maintainability of the decision. Then, my lord, kindly come to uh, 24. Declaration, my lord, was set aside.
Yes.
So, my lord, just, my lord, in conclusion, my lord, I submit, my lord, that on the face of it, my lord, if we look at, my lord, the judgment, my lord, the first, my lord, I relied upon the judgment, my lord, which says, my lord, 3 years. So then, my lord, on the face of it, my lord, could not have been accepted at all. With notice, without notice, my lord, whatever it is, my lord, that being the law, my lord, it could not have been accepted. Here, my lord, completion is 1998. And, my lord, the other facts with regard to, my lord, civil.
Show me the completion certificate once.
Yes, my lord, page 80. Page 80, my lord, is the, sorry, no, completion certificate, my lord, is not, my lord, annexed here. But, my lord, we have stated so. I don't know, my lord, whether, my lord, the other side, my lord.
Page 92 of the declaration, they say that the completion certificate was.
Boleche?
Page 92.
Oh, my lord, my junior points on, my lord, page 92.
Copy of relevant TC.
Copy of date. My lord, it is, I think, my lord, an admitted position between the parties.
Yes, completion certificate 1997, not a dispute.
97. So, my lord, I was saying 98, 97.
Not a dispute on.
Very well.
I'm grateful for that. So, my lord, in conclusion, my lord, I submit, my lord, this registration certificate, my lord, really, my lord, if my lord is wanting to, my lord, dispose of the writ petition today, my lord, should be really set aside. If not, my lord, then, my lord, there's a question, my lord, of immediate, my lord, stay off, my lord, the registration and, my lord, all consequences following thereafter.
I'll just take 10 minutes for the association. What your lordship has heard and what is actually the situation.
Would you like to file an affidavit?
Yes, no, I have to. They've suppressed one suit. They've suppressed their knowledge. There are 2 suits, Mr. Banerjee. There's suppression of one and there's the mention of the other. These people who've come out, you know, there are 13 apartments. I'll just take 5 minutes of your lordship time. 13 apartments. 3, essentially the beneficiary of the 3 who have come is 1 person. However, Manoj, there are electricity bills to show. I have them. Electricity bills to show that out of the 3, 2 don't even stay there. The meter reading is 0. There was a Middleton Manor Association which was there, which was being run
by one of these representatives of these petitioners. You know, they wanted to go and claim a particular terrace which in the deed was referred as a common area. Order 1 Rule 8 suit was filed by all the other members of or the other unit owners in this suit. This is the one that's suppressed. In that suit in City Civil Code, we get an injunction that you cannot claim what is a common area as that to be yours. A terrace is a common area, which is really the meat of the issue here. That suit is naturally, understandably suppressed. They file another suit saying this association, you can't, it's an informal association. You can't go ahead and run or manage this particular this building at all. We take out an application there saying these four who have come before your lordship today have a total outstanding of about 13 lakhs towards common area maintenance that they have not paid. So what they do is they keep it locked. One person's daughter lives in one of these and the others are locked. I'll show those electricity bills. They don't pay the common area maintenance. When the association, before this apartment owners was formed, when the association goes, they say, we don't recognize you, although one of them was a part of the initial formation of the association. They say, we don't recognize you, we will not pay. Then they file a suit. In that suit, we come and disclose that now there's an apartment owners under the 74 Act. Please make the payment that you're liable to pay in terms of the meetings that your lordship has just asked whether meetings were held. Those meetings were held, they were put on notice. They have pictures where because it's locked, I have a person going and standing there. Form E was served. A bigger consideration, my lord. There is not one penny that has been paid from 22-23 by this. So this stay that Mr. Banerjee seeks from your lordship today is to ensure that there is complete anarchy and they don't make any payment. Not a penny has been paid towards common area maintenance. Now, with regard to this aspect of first, this is the basis, and that suit gets suppressed. The first suit.
No, but then why from 1997
I'll tell you,
or
lordship,
8?
this with extreme humility kindly comes back to the first judgment that was shown. Possibly this should have been pointed out. Kindly have a look at paragraph 30. Legally, there could be and I very responsibly make this submission. Kindly have a look at paragraph 30. The right law was probably not cited before, my Lord Justice Bhattacharya. Kindly have a look at paragraph 30. Having not done so, just line about 4 from top, paragraph 30. Sorry, madam.
Yes.
Having not done so for the inordinately long period of 13 years from 2011, when the completion certificate was issued till 2024, then it's held to be ex facie barred. Lord, what should have been, what are you doing, Zohair? Give me the notification by which the amendment came. What should have been pointed out, Lord? Kindly have a look at this notification. This amendment to Rule 2A, which prescribed 3 years. I had a copy though. This amendment to Rule 2A, your lordship will see amendment 1, Rule 2A, period for submission of Form A. This amendment of 3 years comes only in 2016. So the learned single judge was under the impression that delay he counted from 1994. This provision has come into the books only in 2016. Calm down. In 2016. So this analysis, with extreme humility, does not take into consideration how this time period is going to be considered for properties in respect of which clearance certificate has come before 2016. This was not pointed out. Also, so this is something that your lordship will have to be troubled with, because here the analysis in that judgment is 2011 you got or 2013 you got your completion certificate, 11 years you don't do it. What is the effect of this or the interpretation of this 3 years period? That the judgment does not consider. Because the books or this statute is amended only in 2016. So all properties which have received their completion certificate prior to 2016 and 3 years have lapsed.
What was there prior to the amendment? Was any time limit?
So now your lordship will look at the judgment. I'll show one same judgment, but the same learned single judge, where your lordship remembers my Lord Justice Dotto's judgment. He struck down a rule because there was a dichotomy between the provisions of the Act and the provisions of the rules. The Act says the Act shall apply with regard to all majority. The rules came up and said either or. So the rule was struck down by Justice Dotto, saying this is an unworkable situation. I cannot harmonize and read this. So that rule is struck down. So in 2015, the rule was amended, where your lordship would now have noticed that earlier it was all the owners. Now it's become majority of the owners. So from 2015 onwards, to counter Ruidas Devnath, amendment is brought, which is in the nature of a clarificatory or a statute validation amendment, that now majority of the owners also can do it. This amendment gets challenged before my Lord Justice Bhattacharya. He dismisses the application and rejects the challenge to the virus of that new amended rule on the ground that the object of the Act is to encompass within it as many properties as it possibly can be. Because it's a beneficial legislation looking at the class at which the statute is to operate or in respect of which it's to operate. Because now majority can go. Otherwise, situation like Mr. Banerjee's clients is going to come up, where you have an association, he goes files and suit saying you can't do it because you're an informal association. I go under this Act, they say you can't do it under this. So to remove this, the learned single judge holds that looking at the Act, this amendment will have to be allowed, because now just some erring minority members will not be able to withhold the registration under the Act. Properties must come in. This, the other judgment that Mr. Banerjee has relied on, that this 2016 amendment was never pointed out. The learned single judge was under the impression that from date of completion, but your lordship will have this slightly arduous task of interpreting this at all, this provision. Because the first question that fell from the court.
No, I got it. Now you tell me whether notices were issued to everybody.
Notices were issued persons when he doesn't even reside there. I'll be able to show for me. And there have been so many meetings.
He may not reside, but that does not mean
I'll be able to show
that his right will be extinguished. His property is there.
100%. And if I may say this in a slightly colloquial way, the honey lies in that terrace, which is the subject matter of the first suit, which gets suppressed here.
What is the terrace used for?
Well, that terrace, so there's a large terrace.
Yes.
It's in 3 parts. 2 parts are stated to be common areas in all the deeds.
All right.
He has this one part of the 2 parts, let's say A, B, C. He has one part of A and B as an extension of his house. He tries to cover it and put tiles. This part, the remaining apartment owners, by way of an order 1 rule 8, we go and file the suit saying you can't treat this. He suffers an injunction saying this is a common area, because the deeds of all the other apartments ex facie shows that this is a common terrace. So there we also ask him to make payment of the dues of the association. He files a second suit saying this is an informal association, you have no right to run the premises. We go register ourselves here. Now he has notice in May. Not by exchange of letters. Your lordships have held exchange of letters does not postpone the cause of action. From 2013 onwards, your lordships have held that. I'm sure there were judgments before that also. So from May, he doesn't come. May is his declared date of knowledge. He comes up in December, the writ is filed. January, we're moving. If I'm not mistaken, more than 2 of such meetings have been held. And in such meetings, he has been asked to make payment. He doesn't go for any of these meetings. These notices also he gets for these meetings that are to be held there also. And these
does he receive the notices?
Well, I will have to check that, but we go for me and all, we'll be able to show he's received it.
He's received?
Yes, yes.
The petitioners personally or their representatives or something?
That I'll have to check, my lord.
All right.
But I will be able to show that he had full notice and knowledge of this. And this is a person, my lord, I'm equipped with judgment, but it's too hackneyed. that a person who comes and claims or invokes an equitable jurisdiction will first have to be not a defaulter himself. This is 3 people who've come forward out of a group of 13. Just 3 are coming and the remaining all 10 I'm representing, who are saying that you let this property go back to a state of anarchy. Why? He wants that injunction today. Also, in fairness, Mr. Banerjee really does not press the injunction. But he wants that injunction today to resuscitate his other suit. To resuscitate his other suit, because in that suit, we've taken out a 7-11 saying your suit is now bad. We have a formal association. So he gets the stay here. He goes there and he says, look, I have no one to pay to, so I'm not going to pay. So as long as this goes on.
Yes, I have followed. State,
My
I would like a
only
report
request
from
is,
you
Lord,
also.
will allow me short, but some time to file an affidavit. It will be on documents.
I would like to have an affidavit from you.
So that whatever the petitioners have submitted is the part of the representation at page 110.
Did you consider it?
Yes.
Where is it?
And we have sent a notice
When?
on 27 December. Very well. Now,
The representation is of May.
15 December. Your
Lock,
Lordship,
stock,
page
and
110.
barrel.
Today, whatever Mr. Banerjee submitted is.
Which Banerjee?
You have to point out.
Is already a part. Kindly comes to page 110.
110?
Yes.
Yes, 10th of December.
Yes. So here your Lordship can see page 112,
Hmm.
Form E, section 10A, Rule 2A. Whatever he has submitted today is already a part of this representation. On that, we have already acted upon and issued a notice on 27th December.
When is the hearing? Including copy of the letter. Submit a written reply. Dispatched only on the 31st of December. I don't think they have received.
I don't know if my clients have received it. I don't.
Nobody has received. See, 16th of December, this writ petition is filed and copy must have been served upon you. Where is the affidavit of service? Where is the affidavit of service? And it is only thereafter that you jump into action. Yes, after receiving the copy of the writ petition. Now 27th, a letter is prepared and it is dispatched on the 31st of December. Today we are on the 3rd. Possibly they have not received it. And what is your letter? Submit a written reply. The association, your client, has been directed to submit a written reply to the authority in this regard within a fortnight from the date of receiving. Hand over a copy to them also so that they gets to know what is there. What did your clients do after receiving page 56? 17th of May? Nothing. I understand you cannot improve.
Here I, J, K, and L. If your Lordship sees at page 52, those are connected to the representation only.
Yes, he's made submission. Whatever is there in the representation, he's made submissions on that.
If there is a
No, IJ and all are interim models, but prayer C is with regard to his representation. Main prayer
H is there.
Main representation.
prayers and
Please come.
My Lord's pleasure, my Lord, that I give a rejoinder, my Lord, is.
Interim order?
Yes, my Lord, I want to know. Interim order, my Lord, with regard to, my Lord, the certificate and any consequences. Because if I can just reply, my Lord, two submissions. One, my Lord, the 2016 amendment, really, my Lord, would not make a difference. Because, my Lord, the 2015, it came actually in 2015, my Lord, where, my Lord, section 2 was also amended. And, my Lord, that's his prescribed period, then 2A said 3 years. Even if we accept, my Lord, Mr. Banerjee's argument to be correct, then, my Lord, he is more under obligation from, my Lord, 2016 to have that registered, my Lord, within 3 years. That has also not been done.
No, that I'll be able to.
No, I'm just, may I just.
That it's not mandatory.
That's one.
It's
My Lord, there's no question on the law. And, my Lord, there's another submission. My Lord, I'm so sorry. I'm just, my Lord, his, apart from prejudicial aspects saying that suits and all that, my Lord, civil suit can't be defeated by, my Lord, now him taking a step to, my Lord, illegally register, my Lord, an apartment ownership under the Apartment Ownership Act. It, my Lord, works both ways. He can't, my Lord, also defeat, my Lord, whatever rights are pending there.
The petitioners are aggrieved by the act of the competent authority in registering the apartment owners association
Who there is received?
and issuing the registration certificate under the provisions of the Association of Apartment Owners. Now, under the provisions of the West Bengal Apartment Ownership Act, 1972. Stop. A representation before the competent authority was made in May 2024, followed by further representation in December 2024. Stop. None have been answered till date. Stop. The petitioners pray for interim orders restraining the association from taking any steps pursuant to the registration certificate that has been issued. Stop. The learned counsel representing the private respondents submits upon instructions that there has been gross suppression of material facts. Stop. There are 2 civil suits pending in between the parties. Stop. The petitioners have approached this court long after the cause of action arose. Stop. The learned advocate representing the state respondent submits that a notice has already been issued by the competent authority dated 27th December 2024, addressed to the president of the Middleton Manor Apartment Owners Association for submission of a written reply within a fortnight from the date of receiving the letter. Stop. A copy of the letter dated 27th December 2024 has been handed over in court today by the learned advocate representing the state respondents, wherefrom it appears that the said letter was dispatched only on the 31st of December 2024, and the same is yet to be received by the recipient. Stop paragraph. The court has heard the parties in details. Stop. It appears that the writ petition cannot be decided without granting opportunity to the respondents to file their affidavits. Stop. The respondents are accordingly directed to file affidavit in opposition by 24th of January, reply if any by 7th of February. Liberty to mention the matter for hearing immediately on completion of affidavits. Stop. The affidavit of the state shall include all documents which led to the issuance of the certificate of registration in favor of the association, including the notices which may have been addressed and sent to the petitioners. Stop. Next. The prayer for interim order made by the petitioners cannot be allowed because it appears that the petitioners got knowledge of the registration way back in May 2024, but has come up with the writ petition only in the month of December 2024. Stop. The court intends to decide the matter only after hearing all the parties upon exchange of affidavits. Stop. Very well, no further.
Very good.
Service is taken on record.
Some protection, my lord, will provide us, my lord. Otherwise, my lord, if they continue, my lord, with the
That will be allowing is repetition.
no, why allowing? My lord,
What type of protection?
my lord, that, my lord, no further, my lord, on the basis of this, my lord, meetings and all that, if they hold.
This is only owners association meeting. Your suit is pending. Your right is
Correct.
protected.
Now, my lord,
Here also.
the suit, my lord, they will show this and they, what, my lord, my learned friend is submitting. He'll show this and say, sorry, you can't say anything.
He's surprised.
No.
He can't say anything. No, I mentioned it, my lord. That's not correct.
First.
But some protection, my lord, will kindly, my lord, provide. Otherwise, my lord,
I will not take benefit of this order in the suit. That is
no, my lord, in this.
That the court is not entering into the issue of title or ownership of any of the areas involved in the subject instrument.
Yes,
And the writ petition is only restricted to the issuance of the certificate of registration by the competent authority.
that should suffice for Mr. Grateful.
You only saying so. Well, I am no say, my lord, my learned friend. My lord, one, my lord, further request. My lord, if kindly puts a date, my lord, when we can come back, my lord, for the.
Please mention
He'll get lost.
there are other benches taking up hearing matters. So you can try before any of the benches.
My lord,
You
why
have
can't we
options
why can't we come
open.
back, my lord, before this bench? My lord, why can't we, my lord, come back, my lord?
Too
Kindly,
full
my lord,
of
give a date, my lord.
motions.
I
Full
know.
of motions.
That, my lord,
This is
that
the
I know.
difficulty. Otherwise, it's nice. You hear one matter for the entire day.
No, my lord doesn't have the, my lord, doesn't have that, my lord, if I say so, my lord, luxury. Lord, if my lord, returnable date, my lord, with the affidavits, my lord, kindly, my lord, put any date, my lord.
After exchange of affidavits, your matter is ready for hearing and you can mention. You can mention here also. I am giving you liberty to mention. Liberty to mention. Please don't call any other matter.
Lord, Monday, my lord, next matter, my lord. Monday, I have got some personal difficulties, my lord. If it is taken up on Tuesday, my lord, my other side is there.
Tuesday, date একটা দিয়ে দেব. Hearing matter.
Hearing matter, my lord.
It's already past 12. That is the reason I am not.
No, only Monday I have got some personal difficulties, my lord.
Very well.
We'll accommodate my learned friend.
Tuesday, Wednesday, where?
Whenever it's convenient to the business.
কবে দেখুন তো খালি আছে?
Maybe affidavits will
Thursday, আপনারা অনেক দূরে চলে যান। বুধবার 8th. 8th. Have the affidavits been filed or I can
No, my
keep
lord,
it on
it is,
record?
copy has been served, it is lying with the.
Then give, I'll record an order. File হয়নি তো, এই তো দিচ্ছে।
This is reply, my lord.
Affidavit in reply filed in court today is taken on record. CESC, you want to file your opposition or something?
Well, a report has been asked for my lord to submit report.
Where is the report? Then give, I'll keep it on record and circulate the report. Report filed by CES Limited is also taken on record. Stop. Let the report be circulated. Would you like to file an exception without going through it? Would you like to file an exception?
My lord. Well, unless I go through it, my lord.
Yes, how will you know? In that case, it has to be adjourned.
No, my lord, liberty be given, my lord. If it is necessary, my lord, I will file it, my lord.
I'll give you one more week. See, if you want to file,
My
it's
lord.
all right.
My lord.
List the matter on 15th of January 2025. It will be open for the petitioner to file exception to the report.
Parties. Because we don't know which way the report has gone.
It will be open for the parties. Petitioner বললাম তো, it will be open for the parties to file exception to the report filed by CES Limited prior to the adjourned date.
Obliged. Deeply obliged.
Now that the contemner is present and my lord, it has been complied. Order has been complied.
My lord, order has been complied. It is fact, my lord. Well, how it has been complied? Well, each and every occasion when lordship took a
Yes,
hard stand,
yes.
then
Appeal
my lord,
was, I know.
the last occasion, my lord,
after your lordship's order, they released the only area salary. Although your lordship's order was there in terms of EPPU. But they did not release the gratuity.
Now has it been released?
Now it has been released. Now it has been released on 24th. Your lordship, my learned friend mentioned your lordships, and your lordships asked him to come on this next opening day. Then they released the gratuity amount on 26th.
Gratuity, provident fund, everything.
Provident fund, I have received all before. It is my money.
Lord, compliance report is before your lordship. It is being affirmed.
Oh.
Kindly see the copy, my lord. Paragraph 13, my lord, it has been specifically stated.
Tell me one thing, have you received the money?
Yes, my lord. One thing, my lord, I humbly submit to your lordship, my lord. Your lordship's observation is appearing from the order of 19th last date, my lord. That, my lord, in paragraph 3, my lord, can you see the court is not satisfied with the explanation provided by the director of local body?
Yes, I understand.
The retirement benefits. Most surprising is that the date of retirement of the employee is 31st July 2017, and even in the end of the year 2024,
my lord knows everything.
Banging his head from the pillar to post, begging board.
Has any
17, my lord,
interest been paid?
No, my lord. That's why I am seeking, my lord, some.
My lord, whatever calculation has.
But this period will have been no pension. Even the learned friend went up to a higher journey. Appellate court. Appeal court did not trust this order because the appeal court asked them. Even when I paid for expeditious, then the appeal court told that you go and approach because their contempt is pending. So, my lord,
your lordship knows, my lord.
From 17. Retired July 17 till December 2024.
Yes, madam.
Some interest has to be given.
Your lordship knows, my lord, municipal matters. Municipality makes the requisition. They have made paragraph 13, kindly sees. They have made requisition of 26 lakhs.
The court is not concerned. The court wants to see only that the employee is not harassed after retirement.
After.
The court is not concerned where from the money will come.
My lord, it is also, my lord,
your concern also, yes. So some amount of interest to be given to this person who is...
If not given, my lord, if not calculated by the municipality, it should be.
Obviously, you are giving in terms of the PPO. PPO doesn't take care of the interest. Certainly not.
Kindly, my lord, direct that. Kindly direct.
It appears from the submission made on behalf of both the parties that the amount mentioned in the EPPO has since been released. Stop. The employee retired in July 2017, and he is receiving his terminal dues only in the end of the year 2024. Stop. There has been enormous delay in making payment of the terminal dues. Stop. Paragraph. The contemptor would be bound to pay interest on account of such delayed payment.
After the same is calculated by the municipality, my lord, kindly say that. Otherwise, my lord, we will be in difficulty.
The employer would be liable to pay interest to the petitioner. Simple interest. Simple interest to the petitioner at the rate of 7% per annum to be calculated on the amount due on and from the next date of his retirement till the date of actual payment. Such interest shall be credited to the bank account of the petitioner by 20 8th of February 2025. The matter is made returnable on 13th of March 2025.
Only one submission, my lord. Lordship has been kind enough to say 7% simple interest from the next date of the retirement. My lord, kindly say on the pension amount.
What are the other amounts? Gratuity did he receive?
Gratuity.
Gratuity I have
When?
received.
Earlier?
No, no, just 26th December.
6
After
months.
your lordship order, my lord.
6-month period is under the Gratuity Act, your lordship knows.
Even if it is 6 months, then the amount is 10%.
Then, my lord.
Interest rate?
No, I know.
I have made it 7.
My lord, one other thing, kindly see the last order of your lordship. Your lordship has stopped the salary. Stop the salary kindly now, my lord.
Let it remain stopped.
Right.
Why?
He is present personally, my lord. We have taken pain by asking the...
The court is not happy to direct somebody to remain personally
I know.
present.
Particularly this court, my lord, I am conscious of the fact, your lordship...
I am not concerned.
Yes, my lord.
Whether it is only for complying the court's order, for maintaining the dignity of the court, this is to be done.
Which we are part also.
Obviously.
My lord,
It is only through y'all that it can be done. Otherwise, it cannot.
My lord, kindly, paragraph 4.
And when is the affirmed copy of the affidavit
My
of
lord, it is
compliance?
being affirmed. My lord,
All right. Leave to file the affidavit of compliance after affirmation in the course of the day with a copy to you. Achha. The
paragraph 4.
Yes. The court video order dated 19th of December 2024 directed that the salary of the director of local bodies shall remain frozen till the amount due and payable to the petitioner in terms of the EPPO is credited in his bank account.
That has been credited.
Stop. As the amount due to the petitioner has been credited in the meantime, accordingly, the direction of freezing the salary account of the petitioner stands recalled.
Deeply obliged.
Grateful, mother.
The presence of the... Is he present?
Yes.
Give his name also. Give his name that he is present. Such and such person is personally present.
Mr.
Record.
Taposh Kumar Bagchi.
Record it. His personal presence stands dispensed with for the time being.
Grateful. Matter will appear on March, mother.
March 13th. 13th of March.
Petitioner getting this money, your lordship's hard steps. Otherwise, I cannot get.
What can be done? The court has to be harsh at times.
There are things which are beyond control of us also.
I know it.
Your lordship had the vast experience.
Oh, really?
If not vast, at least some experience.
Well,
Next,
at least don't say this to me.
2.
My lord, item number 2, I mentioned yesterday for inclusion in the list. It was released by Justice Chondo because it was filed in the wrong determination. But then, however, it is appearing as for release.
But I
here.
find an endorsement for release there.
Probably that is wrong.
Incorrect?
That is incorrect because this court has the right determination to try this writ application.
Then it will appear in its usual course.
Very well.
Who are you representing?
The state. State of West Bengal and the respondent 1 to 4.
1 to 4 Registrar of Societies. The state of Odisha is also there?
Yes.
And there are so many other private respondents, all from Odisha. One is at Howrah.
My lord, may I apprise your lordship?
No. Certainly not. This is
not on merits. Not on merits.
Scope of hearing that there is no scope to hear it now.
I'm not expecting any order today. This is
without an order, I'm not sitting here to hear stories from anybody. Please come. The matter has wrongly appeared in the list for release. Stop. Paragraph. Learned advocate representing the petitioner, and the learned advocate representing the state respondents submits that this bench has determination to hear the matter. Stop. Let the matter be added in the bundle of motions in the combined monthly list of January 2025. Stop. Let notice be served upon the non-appearing respondents, intimating the date of hearing.
Twofold, my lord, submissions. Twofold submissions. So far as my lord, only my lord state of West Bengal. Let me my lordship recorded state respondents instead of my lord state of West Bengal respondents.
Who are the others?
My lord, the state of Orissa is also appears.
State of West Bengal. State of West Bengal.
And my lord,
State problem, State of West Bengal.
So far as the submission was, my lord, was from the petitioner's end. My lord, lordship recorded it's a joint submission. Instead of that, could it be my lord?
Whoa, is it your submission that this bench does not have determination?
No, not that.
Then
but it is
my lord,
very
only
you
with
say that
regards
this bench has determination.
not my positive submission. I did not oppose his.
No, even if you say this bench does not have determination, I'll release it.
No, my lord, that is not what I was submitting.
The bench, I have not checked it personally. If you say the bench has determination, then I'll keep it in the list. Otherwise, I'll release it.
Because, my lord, very well, let it remain, my lord, we'll make.
Does this bench have determination or not?
Especially as per my understanding, possibly lordship doesn't have.
Doesn't have. So you should have told me. I will release it.
This is coming under the heading of the release.
No.
It is
that is wrong, please.
It's wrongly mentioned for release. It is not for release. Which determination will it be?
It will be either by the Group 9 policing action or by the cooperative.
Absolutely not. Absolutely, a part of it pertains to orders upon the police authorities, but majorly what I am seeking here today before the court is appointment of a special officer who will act on behalf of the board so that we can go at Puri and file a civil suit there, because the board in itself is
connection
defunct.
with a cooperative matter.
No, this is not a cooperative society matter. This is a matter under West Bengal Societies Registration Act, not cooperative society.
Society registration. Kindly have a look into this one, the prayers.
Prayers can be of many folds, my lord.
No,
Listen, I do not know. It is for your.
I have no objection. If your lordship takes it up,
Why will I take a assume or a usurp jurisdiction of some other bench?
Correct.
The bench is full with matters, and I'll
Correct.
take up other matters. Why?
My lord,
I have
my
no
lord, if
objection
the
to my
prayers, my lord, sitting in group 5 in another cooperative society matter that I was about, this is in connection with this matter, be that directed the police to investigate, monitored the entire investigation under group 5.
Right. That was
so prayers can be of many fold. Prayers.
When the lordship was taking that matter, there is a defalcation charge. A complaint has been
Here
made.
also there is a
We have
defalcation
taken the
charge.
steps.
Here also there is a defalcation charge. One property is sold at Puri in
But
my
your
name,
lordship
of
is
which I am
sitting
not
on
even
the
the recorded
nine
owner.
Miscellaneous.
A property is sold at Puri in my name. I am not the recorded owner of that particular property. Sri Jagannath Temple
Wait,
Administration.
let it appear. I'll see what is to be done. Whether it will be before this bench or other bench, I'll see. I do not know. Let it appear as motions. It will be seen later on. Otherwise, at this stage, to be mentioned, the court is going to hunt in which determination the court has to hear the issue.
I'm sorry, Miller.
Call the urgent motions.
I'm grateful.
Joint submission
কি joint submission?
ওটা একটু বলো যে দুজনেই আমরা বলেছি যে এটা determination আমি এটাকে
I will record. I will remove that you are not giving consent. ওনার consent হবে না। শুধু petitioner বলছে that this bench has determination. I'll remove that.
Lordship, I beg to appear on behalf of the petitioner.
Lordship, in this matter, Mrs. Shoma Roy Chaudhary is appearing for the LIC. She is coming. I'm praying for a short passover.
She is coming from where?
This is court number.
She is in the court premises. Let her come. You stay here. Let her come.
Praying for a short passover.
Why? You are here.
Lordship, matter is about.
Can it be passed over for some time? For
Lordship.
Very well. Let it be passed over. 3, 4, 5, 6, all same.
Lordship.
Same.
But another person is there. Another person. Another person is there.
Very well. Call 4. Let me see if somebody appears.
I'm appearing on behalf of the on behalf of Life Insurance Corporation in item number 4.
You are there. All right. Then it's all right.
Affidavit service. Lordship, matter is about the recovery of mature policy claim, Milord, which has been stuck due to having
fraud committed by the staff of the LIC, that is the branch manager.
Fraud committed by the branch manager of LIC.
Lordship. That was happened in the year 2013.
Why are you coming after so many years?
Lordship, when Milord, I several times made a representation before them, they rejected at once. And when the judgment passed by the division bench, I come before your lordship to get relief. I am coming one by one. Milord, I have a policy, Milord, for 12 years policy where I paid for 3 years, Milord. Thereafter, I have been stuck due to having fraud committed by their staff. Milord, there is a settled principle, Milord. Once policy certificate has been issued, payment has been received, they cannot deny. That's why policy till alive. But they have refused to give me my claim. That is the case before your lordship. Milord, there is a law which has been settled, Milord. That is section 5, Milord.
Show me the your policy once.
Lordship. Policy certificate, Milord. That is page number 23, Milord.
না না এটা দেখাই যায় না না আমরা কি দেবো ই করবো অপোজিশন বলে দেখাচ্ছি
Milord, thereafter investigation done by the CBI.
1 minute. Page number 23 is your policy. The date is, where do I get the date? 2010?
28
July 2010?
10.
All right. And is this policy for any fixed term?
Lordship, 12-year terms and payment, Milord, yearly payment, Milord.
Expiry is 28th of July 2023.
Lordship, I have been stuck to pay the premium. That's at that.
You paid premium for 3 years.
3 years.
Till 2013, you paid your premium. 2010, the policy starts.
Lordship, 10, 11, and 12, I paid the amount. And thereafter,
13 onwards, you could not pay.
Due to having fraud committed by their staff.
Yes.
Milord, thereafter CBI filed the charge sheet, Milord. In the charge sheet, there is a list of policy where my policy has not been included, nor I am being called by the CBI. I am not guilty.
Who went to the CBI?
My lord, may I just give a short background of this?
No, please.
Lordship.
He is the petitioner, so I'll hear it from him.
Lordship, there is no scope to appear before the CBI because there is no notice at all of serve upon me. There is no question at all. Any guilty has been committed by me. There is no question at all. That's why I am free from all proceedings.
Who went before the
Lordship,
CBI?
Department
Went.
Lordship. Lordship, that is the page number 24, Milord, where charge sheet has been filed. Milord, there is a list of policy, Milord.
Yes.
Page 31, Milord. Kindly have a look. There is a several policy, Milord. In that list, we have no policy at all. The petitioner have no policy at all.
Yes.
Neither petitioner has been called, Milord. Thereafter, Milord, I total paid, Milord, 64,193 throughout the 3 years, Milord. Milord, thereafter
64,000?
64,000, that is page number 13, Milord. Para 19.
Give me the figure, 64,000?
193, Milord.
All right. Then what happened?
Milord, thereafter, one policyholder go before the writ court, and writ court somehow, due to having COVID and all those things, matter has been rejected, and they given liberty to file afresh, and they file, and that writ petition rejected, and petitioner goes to the Honorable Division Bench. Milord, Division Bench set a principle, Milord. Kindly have a look. Order of Division Bench, Milord, page number 58, Milord. Where, Milord, I want to show 2 page, that is 63 and my lord 65 in the judgment.
Yes.
My lord, in the 63, where division bench recorded that it is explicit from the report submitted by the regional manager, legal, Eastern Zone Office, Kolkata, and the charge sheet that the BOC were fraudulently generated by one C. Devabroto Roy and adjusted for payment of 14 policies of Roy, and the remaining fraudulent amount was adjusted against 275 other policy. The appellant is admittedly not involved in such scam, and LIC authority cannot withhold the benefit of the policy on the pretext of such criminal proceedings. That is one thing, my lord. Another thing, my lord, where lordship can see page number 65, my lord, kindly look bottom portion, my lord. The argument of Roy Chaudhary that the conferment of the benefit to the appellant would open a floodgate is also not acceptable to this court. Floodgate means if this judgment pass on favor of appellant, then all policyholder will come before your lordship. And the same appear to be an argument of dispersion only because there is a possibility of floodgate litigation. The valuable right of the citizen cannot be permitted to be taken away, more so when an instrumentality of the state must conduct its with right, probity, and conduct, and cannot act arbitrarily and unreasonably. There is a settled principle has been said by our honorable division bench that any policy holder may come after this judgment that should be called as floodgate. My lord, my representation, my lord, page number 47, my lord. Page number 47, my lord. It is my representation, my lord, June 22, my lord. Thereafter, my lord, page number 48, my lord. They admitted that policy has been generated in my life, in the name of my life. Kindly have a look, my lord. First question, my lord. Reply of query number 1. The policy being number such and such, that is the policy of the petitioner, was issued on the life of the Gupteshwar Nath Upadhyay. There is a reply of the RTI, my lord. But at present, any payout from the said policy is restricted as per the order of the competent authority. Competent means their authority, they withheld all maturity, my lord. This is the story, my lord.
The reply to query number 2, please read out.
Lordship, they admit that the payment has been made. That is question. Reply to question is yes.
First premium received under the aforesaid policy had not been paid.
Lordship,
To ask
that is their version. That is their version. It has been paid and commission has been paid to the agent also. Agent also, my lord. Kindly go to page number, my lord. I'm giving the page number. $68 million. $68. All payment has been made to the agent. How they made that kind of amendment in the?
No, did the agent deposit in the account of the LIC or the agent just
Lordship,
digested the money that you paid?
It is my submission, my lord. When agent got the commission on particular this policy, how they, after issuing the policy certificate, my lord, they cannot say something like that, because without having payment, my lord, policy certificate cannot be issued. Without any payment, my lord, policy certificate cannot be issued. It is the principle of law. They cannot deny at all. My lord, kindly have a look. 2012, 2011, 2010, my lord.
Hmm.
They got the
Premium.
got the, my lord, commission in respect to that policy.
Where from? Oh, the commission amount is also there.
Lordship, policy number is top of the left side.
Where from did you manage to get this?
Lordship,
Under the
Lordship,
RTI?
somehow I have to, is the agent of the LIC, my lord. They have access to get some paper from because they are doing since long.
All right.
In the department, LIC department.
Whose
Out of-
signature is this? Bidhan Bhattacharjee, Assistant Branch Manager, Sales,
Lordship,
LIC,
it
page
has been-
68.
It has been attested by the branch manager, my lord. It is the Xerox copy.
Senior Branch Manager.
Also, it has been attested. That's been admission. My lord,
And the amount that you have paid,
Lordship,
21,000, 21,000,
total amount paid,
21,000.
my lord, I say page number 13, my lord, para 19.
Page 68 also the installment premium
64,
amount.
193, my lord.
All right.
There is a little amount, my lord. And my lord will suffice to know, my lord, certificate of the policy also has been attested by the branch manager recently. My lord, kindly have a look. It is
All right,
Xerox
you
copy.
keep it. Then, so you want your money back, the
Lordship,
amount that you
Lordship,
have paid.
Kindly,
64,193. You paid till 2012. You want that.
Lordship, along with all interest and all benefit.
Whatever the benefit is there.
Lordship, my prayer is that.
So let me hear the LIC now.
G, my lord. My lord,
G.
prayer G. Page number 20.
Consider payment to the petitioner for his investment with 12% compound interest. Where from are you getting this 12%?
Lordship, there is a proposal, my lord, that can be 10 or 7. That is the defined thing.
Accrued
That should be
compound interest at 12 since 2010 with suitable compensation. Whatever. Let me hear the LIC.
Lordship, 1 minute. Proposition of law is that in contract act section 5, my lord, revocation of proposal and acceptance. My lord, a proposal may be revoked at the time of before communication of its acceptance. Is the complete as agent in the proposal, but not afterward. That is the settled period. One, they get the money, they issue the certificate.
Yes, I followed. Yes.
My lord, may I? My lord, what my learned senior friend is trying to place before the matter is not that simple. My lord, first and foremost, if a question may be put to my learned senior friend's client, that let him show a single document to show that he has deposited the money with Life Insurance Corporation of India.
But then life insurance, please
now-
wait, don't reply now.
Yes, my lord. Kindly bear with me for 2 minutes, my lord. What has happened? This is a matter of a big fraud that has been committed by several agents and the agents as well as few of the persons of LIC itself. Now, my lord, what has happened? There was a fund of LIC. This fund belongs to LIC itself. That fund has been utilized. LIC's fund has been utilized to generate several 300 or 400 several fake policies. Now, this policy paper, which my learned senior friend is trying to rely upon, because 4, 5, 6, this item numbers, I am appearing in item number 6. This particular document has been generated from the office of the LIC, but utilizing LIC's own fund. The money, what my learned senior friend is trying to say, has been paid. This money has been, he is saying that this money has been paid in cash. My lord would be aware that LIC being an institution never accept cash premium payments. What has actually happened is that this cash amounts that has been collected has been utilized by the agents or the commission who has committed the fraud. Now, this policies which has been generated utilizing LIC's own fund. Now, when this fraud has come out, a CBI investigation was taken out. Now, this is the charge sheet which my learned friend has already relied upon, and this charge sheet clearly says and in detail how this fraud has been committed, what has been done, and LIC's own fund has been utilized to generate those policies. Their money has never reached the office of LIC. What my learned friend is trying to rely upon is a commission book. That is a commission book of an agent. He is relying upon every time. Now, my lord, if my lord kindly takes up, because this is very important, a coordinate bench judgment very recently on this matter, item number 6, if my lord takes up the page number 21 once,
Tell me
because
once,
it has detailed.
Page 23 is this
My lord, I'll
document.
beseech my lord to kindly take up item number 6.1, because that is the document I'll be relying. I'll come back, because that is this document which my lord is relying upon, it has not been annexed. Item number 6, page
Lordship,
number 21.
Lordship, in this matter,
My lord, may I complete? My learned friend will reply. Allow me to place the
in
facts.
item number 6, my lord, I have been given liberty to
Yes. I'll
approach
show
before
my
the
lord,
LIC to show the
I'll place
document.
the entire
That document we have.
entire judgment, and the division bench judgment which my learned friend has been relying upon, that division bench judgment, thereafter there was a review that has been preferred. Against that, SLP is pending. I'm carrying that orders.
No
Now,
stay
my lord,
order.
kindly,
I am appearing before the Supreme Court. No stay order.
Wait. Yes.
kindly, my lord, page number 21. May I just be allowed to place? My lord, from the first only mid portion, the petitioner has not been able to show any document which would indicate that LIC has accepted the premium of 2 lakhs or had acknowledged the payment made by the petitioner and correspond with the petitioner as to the method of payment, unlike the case before the Honorable Division Bench. Learned advocate for the petitioner submits that rupees 2 lakh in cash was handed over to the agent. There is nothing on record which would indicate that the agent has deposited the money and the same has gone into the account of LIC. There is nothing on record which would show that LIC had ever acknowledged the petitioner as an insured. The policy certificate has been alleged to have been fraudulently procured and is the subject matter of criminal trial. The learned advocate for the petitioner contended that the petitioner may have misplaced the receipt. However, there is no specific averment in the writ petition that the money was deposited in the account of LIC and LIC had granted a receipt. There is no averment which would show that LIC had inquired from the petitioner as to how she would want to pay the premium. These are distinguishing factors with the matter disposed of by the division bench. In any event, the order of division bench has been challenged before the Honorable Apex Court. Learned advocate for the LIC submits that LIC could not accept rupees 2 lakhs in cash towards payment of premium. Acceptance of premium in case was beyond the rules. All these policies were the subject matter of an investigation by the CBI. A charge sheet has also been filed. Fraud has been found to have been committed in collusion with some of the staffs of LIC. It has been alleged that such and such misappropriated huge amount of money by debiting the account code and by withdrawing the money upon preparing vouchers in fake names. The names printed on the vouchers generated through the machines were subsequently altered by him in favor of LIC as the payee. This was done to create a wrong impression of plowback investments. The checks so generated on the basis of these vouchers were deposited in cash counters of LICI branch as proposal deposit premium renewal premiums. In 114 vouchers, the signature of such and such appeared. The CBI has already investigated and filed a charge sheet which finds the involvement of such and such in creating a huge number of fake policies. The charge sheet clearly indicates that the several of such policies were created by such and such, and it is the specific contention of LIC that the policy of the petitioner was also a matter of such investigation, which has now ended in a charge sheet. Thus, the question of release of money does not arise. Under such circumstances, a direction to pay out the amount insured by such policy cannot be permitted by the writ court. This court is not inclined to pass as any order. However, if the petitioner is able to show any receipt from LIC upon acceptance of 2 lakhs, in the event, the petitioner may approach LIC for necessary consideration of the case. This order has been passed on 12th of August 2024. Now, my lord, this is a second round of litigation. To an extent, item number 6 is concerned. My lord kindly keeps the file with my lord for once and kindly come to page number 30. Now, after this order, he approached LIC and he deposited 2 documents. Court has specifically asked that if you have paid 2 lakh, if you have paid 2 lakh, 3 lakh, whatever, if LIC has accepted, my lord, we all know, anywhere we go, if I pay a amount, I get a receipt. I put this question to myself, where is that receipt? Only one simple question. If the premium has been paid, he has to have an acknowledgement.
Tell
Now,
me
my lord.
whether page 23 in this writ petition, item number 4,
Yes, my lord.
a certificate is annexed, a policy certificate.
Yes, this is what has been observed by the coordinate bench, that these policy certificates are fraudulent documents.
So you
What
say
has
this
been
is
yes, yes.
Please.
My lord, this is our specific contention that all these documents are fraudulent. My lord, what has happened? If my lord, at your leisure, kindly go through the charge sheet, my lord will understand the entire fact. What has happened? There is a huge fund of LIC that is lying with LIC. Now, this person's LIC agent, they have access to that funds. What they did, they debited LIC's own fund to generate these fake certificates. And what they did, after generating this fake certificate, they accepted the cash from them and in return gave them these fake certificates. Now, when
these people have been taken for a ride.
My lord, that's a part of a fraud and a criminal investigation. I completely bow down to what is going through my lord's mind. But it's a part of a criminal investigation. Now, the fraud has entirely been not only committed on them, fraud has been committed upon LIC also. Because such money, huge amount of money has been debited. That is also a public money. That has been debited from LICs, from the other persons who are taking premium, who are giving premiums and validly taking those policies. It is their money only. That has been siphoned off. And at this, for generating those fake certificates.
What steps are you all taking against these?
CBI invested, charge sheet file, criminal trial.
Who approached the CBI?
My lord?
Who approached the CBI?
LIC only. Once this fraud has been detected, immediately we approach the CBI, because this is something, my lord, that's why I said, my lord, at your leisure, my lord, if sees the charge sheet, my lord will understand the entire thing. Charge sheet has already been annexed to this petition.
But then
now, my lord,
it's the account number, the policy number which the petitioner is referring to, also a part of the charge sheet.
Yes.
It
kindly allow me. Then, my lord, in that event, allow me to place the charge sheet. My lord,
there is a policy number at page 23.
My lord, these are the policy numbers which my lord is seeing. And these policy numbers, these are the numbers that has been generated by this Debobroto Rai in his own favor. But apart from that, my lord kindly comes to the internal page. My lord takes it from the beginning and skip over.
Very well, 1 minute.
Kindly come to the 4th page.
Oh, 1 minute. Did you approach the LIC for payment?
Lordship,
where is it?
That is my representation, my lord, page number 47.
My lord, that is what I was showing from my
senior divisional manager.
47.
Is he the authority to consider it?
No, my
Lordship.
No.
No, my lord. I'll
Who
just
is the authority? You tell me who is the authority who
my
can
lord,
consider.
it has already been
Lordship.
considered. But my lord, I'll kindly allow me. He has approached. What has happened? If my lord takes up item number 6, my lord, since I'm only been briefed in item number 6, they brief different people for different matters, my lord.
Lordship,
Item number 6, page number 25, pursuant to Justice Shorka's order, this was the representation that was made and by the petitioner to LIC. Representation has correctly been made and court has directed you if you have deposited 2 lakhs, you provide the receipts.
Any receipt, not receipt. Any receipt of the.
Wait, why are you interjecting?
Now, my lord, at page 25, my learned senior friend's client has duly given a representation wherein he has said any receipt and he relied upon certain documents. Now, my lord, kindly skip over and come to page 28. What are the documents that he has relied upon?
Listen, we are not in item number 6 now. We are in item number 4.
But issue is same.
Thing is,
the matter is same.
The petitioner has filed a representation before the senior divisional manager. Can he consider his case or not?
Definitely, my lord.
Let him consider and pass necessary orders.
Passed and it is in order. That would be.
I would like to file affidavit in opposition, my lord.
No, please come.
Presentation.
Lordship,
But my
kindly,
item number 6,
My
I'll make my
Lordship, allow
submission.
me kindly file a
Lordship.
status. My lord, kindly allow me file a status report. My
Lordship, kindly have a look, page number 48, my lord.
48.
48, my lord. They admit
Presentation.
it is my
Very well,
fault.
you submit all your documents over there.
Lordship. Original document
Petitioner-
already has been submitted, my lord, before the
petitioner
LIC.
claims to have
we would like to file a affidavit of which
obtained
my lord, kindly consider
a
my lord.
policy under the LIC's apostrophe S, New Bima Gold in the year 2010 and claims to have paid premium till 2012. That is for a period of 3 years, amounting to rupees 64,193. Stop. Paragraph.
Lordship, another
According
figure.
to the certificate annexed to the writ petition at page 23, the date of maturity of the said policy was July 2023. Stop. Paragraph. The amount paid by the petitioner, the amount allegedly paid by the petitioner is yet to be refunded to him. Paragraph. A representation from the end of the petitioner before the senior divisional manager is pending consideration. Stop. Learned advocate representing the LICI submits upon instruction that the document at page 23 of the writ petition, that is the policy certificate, is a fake and fraudulent document. Stop. No payment was ever received from the end of the petitioner by LICI. Stop. There has been a fraud. No, a fraud has been detected by the CBI and a criminal investigation and trial is pending. Stop. Charge sheet has been filed in connection with the criminal case. Stop. Paragraph. Be that as it may, as it appears that a representation from the end of the petitioner seeking refund of the amount allegedly paid by him is pending consideration, accordingly, the court is not inclined to decide the issue here and now. Stop. The senior divisional manager, being the respondent number
6, my lord.
6 herein is directed to consider the prayer of the petitioner in accordance with law.
Lordship, some of original document already has been submitted before the LIC.
In accordance with law, after giving the petitioner a reasonable opportunity of hearing, at the earliest but positively within a period of 6 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner.
5.
Stop. Paragraph. The aforesaid respondent shall intimate the petitioner the documents that he is required to submit before the authority for receiving payment, if any. Stop. The writ petition stands disposed of.
Lordship, in page number 13, my lord, there is another pending amount which is pending before the LIC, my lord, that is already averment in the writ petition, my lord, 13,231, my lord. Kindly have a look, page number 13, my lord, para 19.
Page number 13.
13, para 19. 19.
You said you paid for the year 10, 11 and 12.
Lordship, and my lord, balance that policy which has been submitted before the one policy has been matured, that amount submitted before the LIC generate new policy in the name of the petitioner and balance amount rest laying with the
Whatever is there, you mention in your representation, they will
Lordship,
consider.
kindly, my lord, mention the amount, my lord, so that I can approach before the LIC authority. That would be rightful, my lord. Otherwise, I'll go away. Little amount, my lord, 13,231.
The amount allegedly deposited by the petitioner before LIC, as mentioned in paragraph 19 of the writ petition, is rupees 64,193 and rupees 13,231.
Lordship.
No, my lord, this item number 6 is a bit different.
Wait, I'll come to 5 first.
Okay, my lord.
Item number 5.
One thing is that, my lord, fraud committed in the year 2013. My policy since there are before.
I do not know what is it. Yes. 5. This is item 5.
My representation is
for the LIC.
Nitin
my
Patel.
representation is page number 47, my lord.
47. Where is your certificate?
Lordship, page number 23 and receipt, money receipt 24, 25.
Who is for LIC?
My lord, I'm appealing for them.
Policy, you say, page number 23.
23, my lord, and receipt 25, 26. 24, 25.
23,
4, 5,
24, 25.
Subsequent
Achha.
receipt.
Here, how much have you paid? 2010?
I have paid, my lord.
The policy date is 2010.
Yes, commencement
Right,
date
commencement date. And last payment?
of 2020, my lord.
2020. From 10 to 20 you paid?
No, my lord. I have been restrained due to having fraud committed by them.
How many premium did you?
Three.
3.
Page
10,
number
11, 12.
5, 6. Page
24,
number
5,
5,
6.
24, 25, 26.
How much is the amount? Is it
That's the
mentioned in
amount.
your representation?
Lordship.
Then it is all right. Same thing, fraud has been committed.
Lordship.
And this page 23 is fraudulent.
Now, my lord, as and when, my lord, only one difference is, my lord, as and when it was detected, we informed them and issued a letter to him that this has been detected. You give us the original money receipts so that we can avail of anything what we can do for you. So that was in 2014. My lord, he doesn't produce anything.
Where is that letter annexed?
No, my lord, he doesn't annex those.
All right.
He doesn't annex those.
If you have, then show.
Sorry?
If you have, then show.
This is the letter. By registered post, it has been sent. I had a set of
There may be so many unsuspecting these type of persons who may fall trap to this.
Absolutely, they have
Fraud
fallen,
also.
and it's not one; it's 284 frauds
Persons.
policies.
Policies.
Yes. And total value has been calculated by CBI is 3.84 crores.
But fraud committed by their person, not Investor. Investor why should suffer? That is
And my lord, the
my
issue is,
question.
my lord,
No, but then if your money has not reached the LIC, you cannot expect LIC to make payment to you.
Lordship,
That cannot be done.
LIC get the amount. That's why money seat
LIC has never got the amount. This is what has been submitted. It is LIC's own amount that has been used.
Lordship,
No, no, it's
money seat has been generated. That's why.
this is also false.
That is their part.
Not their part. Where from are you showing this document?
my lord, this they have
Instruction.
yes on instruction.
All right.
We asked him to produce the original money receipt, the original bond, everything.
Very well, please come.
We will submit original, my lord, before the
The petitioner prays for refund of the amount deposited with LICI in terms of the Jeevan Anand policy. Stop. The policy allegedly commenced in December 2010, and the petitioner claims to have paid the premium till the year 2012. Thereafter, the company refused to accept payment on the ground that an investigation was continuing in the matter. Paragraph. The date of maturity of the said policy is in the year,
My lord, 2020,
December 2020.
that is the last date of payment, and that is the date of
2022,
maturity.
lordship, 2022 maturity.
It's 2022. Stop paragraph. A representation made by the petitioner before the manager within bracket CRM/CPIO is pending consideration. A representation before the manager seeking refund of the payment made is pending consideration. Stop paragraph. Learned advocate representing CESC Limited.
Yes, LIC.
LICI submits upon instruction that the document that the policy document annexed to the writ petition at page 23 and the money receipts at pages 24, 25 and 26 of the writ petition are fake and fraudulent ones. Stop. LIC never received any payment from the petitioner. Stop. The petitioner was intimated by a communication dated 15th May 2014 for production of the original documents showing payment for policy verification. Stop. The petitioner never responded to the said communication. Paragraph. Be that as it may, without entering into the allegation and the counter allegation of the parties at this stage, as it appears that the prayer of the petitioner seeking refund of the payment allegedly made is pending consideration at the end of LICI. Accordingly, the instant writ petition is disposed of by directing the earlier one was senior divisional manager. Should I make it
same person?
Same person. The senior divisional manager, Life Insurance Corporation of India, being the respondent number 6 herein, to consider the prayer of the petitioner in accordance with law. At the earliest, after giving an opportunity of hearing to the petitioner within a period of 6 weeks from the date of communication of this order. a reasoned order shall be passed and communicated to the petitioner. Stop. The aforesaid respondent shall intimate the petitioner the documents which he is supposed to produce before the authority for receiving his claim disposed. Can you give a copy
Yes,
of
yes.
this
Yes, yes.
15th May
Yes, yes. Can I
24
just
so
open
that I
it
can
up and
keep
hand
it?
My lord can keep that
And
entire. I have a photocopy of this.
then the whole thing,
Whole thing.
the instruction,
Only back sheet.
handed over by the received by the learned advocate representing LICI,
Lordship, kindly direct them to serve the copy.
be written with the
May I
records.
just open the back sheet, my lord? That
Yes, yes, please do.
Lordship, may I know one copy, my lord, may I get?
Yes, yes, you
letter
give a copy. This is a letter addressed to you only.
My lord, may I be permitted for one indulgence, my lord? In item number 4, on behalf of Life Insurance Corporation of India, I have already issued a letter to the petitioner for claiming for producing the document of policy bond first premium receipt.
Why did you not mention it? I could have included it.
All original
Give-
document has been submitted.
Give a copy of that so that I can keep it.
My lord, I give the Xerox copy, my lord. Kindly give me liberty, my lord. I will file. I will file it on same day.
Yes, yes. Is the date same?
No, same day.
14th of May or something? What is it?
15 May, my lord.
15th of
I'll record it, my lord. In the
এই যে লাইনটা বললাম না
4.
এটা 4 নম্বর অর্ডারেতেও যাবে 4 নম্বর থেকে নিয়ে নেবেন না এই অর্ডারটা 4 নম্বরেও যাবে এই লাইনটা 4 নম্বর প্রদীপ নিয়েছে প্রদীপ নিয়েছে
Well, I will file.
ওইখানে তো যাবে
I will file it today.
ঠিক আছে কোনটা বলেন তো 15
4 number order টা তো
হ্যাঁ হ্যাঁ yes 6
Yes, ma'am. Well, 6 is a bit different because this is a second round of litigation.
yes
And my lord,
did you
as I have-
consider the
Yes,
representation
my
where
lord,
is the reasoned order
my lord, page 33. Prior to that, my lord, the representation that has been made is at page, I just placed 25.
yes
So pursuant to Justice Shorka's order, this was the representation that was made. And what document he has annexed is at page 28. My lord would kindly see it is a agent's proposal and policy register. It is not a document issued by Life Insurance Corporation of India. It is an agent's
I
proposal
didn't
and
get it
policy.
I didn't get it which page are you showing
My lord, page 28. These are the document that he has
all right
relied. Now, my lord,
agent's
two
proposal
documents. Agent's book. Now, my lord, at page 30, he relies upon another document. What is the agent's commission book? See, my lord, as I have already made my submissions. So, my lord, basis this representation, we have duly considered, and the answer is at page 33, second paragraph, last line. We have stated that we find that you have not submitted any receipt issued by LICI towards acceptance of one-time premium of rupees 2 lakhs. My lord, the same stand that we have continuously been saying has been placed by my learned friend 15th May 2014. So this is the letter that has been issued to all these 283 policy holders that if you have paid, a simple question, if you have paid, you must be having a receipt. You please show us the receipt.
yes what is your
Lordship,
submission
In the order, my lord, where
listen page 33 is the impugned order
Lordship, that is
where is the receipt showing
23.
payment
Bottom portion of the order, 23. If petitioner is able to show any
Petition
receipt,
bench order
1
already
minute.
considered.
yes if the petitioner is able to show any receipt from LICI
any receipt, my lord. I have shown the receipt which has been issued by the LIC, my lord.
where is it
But that is the document, my lord, which is showing 30 and
page
Lord,
30
30
is it
and
issued by
28.
LIC
Lordship,
is it issued by LIC
Lordship,
where
28. My lord,
where is it where is
completed
it
business, my lord, remarks here of the acceptance.
sorry sir this is the agent's proposal
Lordship,
you fight it out with your agent there
Lordship,
is Some
Lordship,
problem somewhere. No, it cannot be allowed.
there is a policy which has been showing, my lord.
These are all fake
Agent,
and fraudulent policies.
Lordship, commission has been paid to the agent, my lord.
The
That
agent,
that is the
the agent has been prosecuted. You fight it out with him. LIC cannot be directed to shoulder responsibility of anybody who accepts money on the name of LIC. Please come.
Lordship, my lord, kindly, my lord,
And
give
my
me
lord,
one
one
opportunity.
surprising factor, my lord, will consider in all these writ petitions, nowhere the agents has been made the party. If they have paid the money directly to the agent, what precluded them from making the agent as a party? Let the agent come and say how he has received the money.
The petitioner is aggrieved by the impugned communication dated 30th August 2024 by the manager within bracket L and HPF, comma, LICI, rejecting the prayer of the petitioner for refund of the money allegedly deposited by the petitioner as one-time premium in respect of a policy of the company. Stop. The impugned communication clearly mentions that the petitioner failed to submit any receipt issued by LICI towards acceptance of the one-time premium of rupees 2 lakh. Stop. Learned advocate for the petitioner draws attention of the court to the document annexed at pages 28 and 30 of the writ petition in support of the submission that those documents were issued by the LICI evidencing receipt of payment. Stop. Paragraph. On a perusal of the said documents, it appears that one of it is an agent's proposal and policy register, and the other is the agent's commission for certain policies. Stop. There is nothing on record to show any receipt issued by LICI accepting payment of one-time premium of rupees 2 lakh. Stop. It is the consistent stand of LICI that the documents relied upon by the petitioner are all fake and fraudulent ones generated by the agent.
Lordship, it is not generated by agent.
The
LIC.
staff in collusion with the
Generated by some of the staff in collusion with the agent. Stop. Next.
Lordship, in division bench, there is no
The
allegation against the agent.
it appears that there are several disputed questions of facts which cannot be adjudicated by the writ court. Stop. The authority contends that the document relied upon by the petitioner is fake and fraudulent. Stop. The writ court is not in a position to adjudicate the genuineness of the said document. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant case. Stop. The writ petition fails and is hereby dismissed. Stop. It will be open for the petitioner to approach the competent forum for relief if so advised.
I'm great.
Lordship, one passover matter, my lord. Item number 3, my lord.
Yes, ma'am. Well, I beg your pardon to come in late. Yes.
Lordship.
It is the same thing?
My lord,
Lordship.
more or less same, my lord. My lord, the petitioner says that purchased the policy in 2009. And my lord.
Got committed 2013, my lord.
My lord, since petitioner has self said, my lord, your lordship, kindly page 7, that it has been alleged FIR Sri Devabroto Rai. Your lordship, kindly see page 7, para 10, subpara 1.
Yes.
It has been alleged in the FIR that Sri Devabroto Rai, during his tenure from 2nd December 2008 to 29th May 2019, 13, in CBO such and such, LIC committed a fraud. And my lord, this is 2009 fraud. And my lord, thereafter, my lord, he has made representation before the authority, page 45.
Please come.
And my lord, page 45, on my lord, 11th of July 2024. And my lord, writ petition filed on 24th of July 2024, just 13 days after 13 days.
The petitioner claims refund of the amount paid, allegedly paid to LICI for a policy, within quotes, Jeevan Anand,
Yes.
which commenced in the year 2009 and paid premium till the year 2012.
11 minutes.
Achha, 11. Stop. The date of maturity of the said policy is
26. Well, you also kindly page 22.
no, that is the last date of payment, and the it is
It is
valid.
fabricated document. It is
August
also.
26, Milord.
Acha.
Milord, fraud committed 13, Milord. How it is fabricated?
No, since 2008 to 13. 13 was detected.
Sometime in the year 2026 or thereafter. Stop. Paragraph. The petitioner seeks. Now the petitioner made representation before the authority seeking refund. Stop. Paragraph. Learned counsel representing LICI submits upon instruction that the policy document and the money receipts annexed to the writ petition are all fake and fraudulent ones. Stop. The LICI never received any amount as premium from the petitioner. Stop.
No, my
Next.
lord. First premium has not been made, but my lord, second premium in cash, he has given in cash. But my lord, policy, first premium has not been made. Made.
Very well. কি বললাম? The petitioner has এই লাইনটা কেটে দিন। The petitioner has averred in the writ petition that
ওই লেটারটা এই লেটারটা ওকে দেওয়া হয়েছিল
a fraud has been detected,
দিয়ে দেবো
an FIR has been filed against one Sri Devabroto Ray, a staff of LICI, and a CBI investigation and trial is pending. Stop. Next. The petitioner, by a communication dated 15th May 2014, was directed to produce the original documents for policy verification, but the same has not been produced till date. Paragraph. Be that as it may,
Lordship, I have
as it
submitted
appears
our
that
original document, Milord, before the LIC.
as it appears that the representation filed by the petitioner seeking refund is pending consideration at the end of LICI. Accordingly, the court is not inclined to enter into the merits of the allegations and counter allegation of the parties. Stop. The instant writ petition is disposed of by directing the senior divisional manager, being the respondent number 6 herein, to consider the prayer of the petitioner in accordance with law, after giving him a reasonable opportunity of hearing, at the earliest but positively within a period of 6 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner immediately thereafter. Stop. The petitioner shall be made aware of the documents to be produced by the petitioner for obtaining refund of his claim. Disposed. Service taken on record.
Grateful. Will.
May it please your Bishop.
So my learned senior friend starts, I would beseech to have some more time to file the affidavit in opposition.
No, my lord, may I?
I'm praying for extension of the time because, my lord, it's a strange matter. As a matter of fact, the affidavit was ready within the time. But subsequently, there has been some search, seizure, which are required to be included in the affidavit. That is why I require some more time. My lord. They have an interim order which is subsisting still 10th of January. If your lordship extend it for a few time, whatever your lordship deems fit.
My lord, may I just make one submission? My lord, this CAN application is for disposal of the writ on an admitted fact. My lord, the affidavits have not been filed in the main writ. My lord, the directions.
We have not received it.
1 minute.
My lord, what has happened, my lord, is, my lord, the enforcement directorate, my lord, can only, my lord, act on the basis of there being a predicate offense. Now, my lord, here, in respect of a lookout circular was issued. My lord, my client was not even a named accused, my lord, in the FIR. My lord, my lord, please. My lord, on that basis, my lord, we, my lord, challenged, my lord, the lookout circular which was allegedly issued. We succeeded in getting an interim order because, my lord, the memorandum which provides guidelines, my lord, regarding LOC, my lord, had not been, my lord, followed. But, my lord, what happens next is the predicate offense in respect of that, my lord, the final report has been filed and, my lord, there's a closure report. That closure report has now been accepted. So if there is no predicate offense, my lord, there is no question of any lookout circular remaining now. That is our case. And there is no challenge. My lord, my lord, this, my lord, closure report, which has
Where
been
is the closure report?
My lord,
in the
kindly come
supplement?
to, yes, my lord, kindly.
Volume 8.
My lord, volume 8, page 2051, 205.
That means in the writ petition itself, it is annexed.
It's a subsequent fact.
This is a subsequent fact, my lord,
In
during
the
the
CAN?
pendency of the writ.
In the CAN, did you file it?
Yes, in the CAN.
I have not received.
Not received the CAN?
I have only 3 volumes of the writ petition.
My lord, affidavit of service, I'm told, has been filed, my lord.
And even yesterday also he was.
Lordship, Union of India has received your lordship.
They have received.
I'm appearing.
India has received your
I have
learned
not received
friend
anything.
for the
In fact, my lord, the interim order was also there when we were not present. However, the Honorable Court has recorded that despite service, it received us belatedly. I'm not on that. Today, no CAN application of 8 volume, my learned senior is saying, I have not received.
না না সার্ভ করা হয়েছে কিন্তু ইডিকে সার্ভ করা হয়েছে
কোথায়
এই তো এই যে
My lord, my learned friends being served. My lord, I don't know, my lord, why.
check up.
Sir, 2nd January, বেলা 12:15 আপনি
সব হয়েছে তো
But if this is a service, my lord, an email intimating that the matter will be taken up by your lordship. And kindly see for one.
See, we are not
Intimating
going
that
into
this
all-
matter will be taken up today. It was mentioned, your lordship permit.
You don't have the copy?
No.
Please forward at least soft copies, 8 volumes. or
8
what?
volumes, my lord, we will, my lord, forward again. My lord, kindly see, my lord, they all forwarded.
Sir, আপনি ইমেলে বডিটা একবার দেখুন স্যার কাইন্ডলি
আরে
অ্যাটাচমেন্ট হলো সমস্ত
kindly see no attachment has been referred here also. Just intimated that second mentioned matter will be taken up on third. Regards.
পাওনি বলছো আবার পাঠিয়ে দাও
But I request hard copy, my lord, 8 volumes. How can I do on soft copy, my lord? Kindly, I request.
You can request your clients to provide you with the hard copies. For your perusal, let the soft copies be forwarded
My
to
lord,
you at least.
we would be requiring to file affidavit in that
No,
can
there's no
also.
question of, my lord, affidavit here, my lord, it's It's been accepted, the closure report.
Because they
I've-
can.
I've
my-
got
I
my
understood.
orders of court
It's a
accepting it.
different cause of action.
No, I've challenged the lookout circular,
Different
saying
cause of
it's bad. Now, my lord, during the pendency of the
Go through it. What is there, you do not know.
No, what
as
my
of
Nana
now.
Singh said. I heard what he said.
Yes, but then you go through it and then you come
I'll
back.
come. But keep
Because,
it-
my lord, the interim orders till the 10th, my lord, kindly keep it before that, my lord, so that, my lord, it can, my lord, be disposed of, because it cannot survive, covered by Supreme
10th
Court.
is next Friday.
Yes.
Very well, man. Keep it on next Friday. I will come back.
Applications 7th.
And by that time, will your opposition be ready?
I'll try. In the writ petition, I will try to do it by Wednesday at least.
Serve an advance copy to them so that they also get to know what is there. Please come. It has been submitted that the interim order is subsisting in the matter till 10th January. Stop. Let the matter appear in the list on 10th. Stop. Let soft copy of the connected application be served on the learned advocate representing the Enforcement Directorate. Stop. The affidavit in opposition by the respondents have not been filed till date. Paragraph the minute. Let the same be prepared and circulated by 8th of January 2025. Stop. List the matter on 10th. And madam, are you ready with the instructions? With the
My lord, subject to your
Your Lordship, the main answering respondent, ED, Your Lordship. We are just the custodian of the LOC, Your Lordship.
It cannot be on the 9th because
well.
9th is a Thursday and
Very well, my lord. I
applications
know,
and
my lord.
everything.
Application day. 9th the application.
My lord, 9th is an application day, though,
essentially application
because
is-
we are really on the can. Anyway, my lord, 10th is fine.
One is can 1 and the other is can 2.
Yes, can 2, my lord, is what
Can
we are.
2.
And what is can 1?
Can 2. Can 1 did you receive?
Everything.
None.
Can 230th.
I'm only having 3 volumes of the writ petition.
And the writ petition is of 3 volumes.
26th of August, can 1 was served. 30th of November, can 2 was
1
served.
minute. How many volumes is the writ petition? Is
Writ
it
petition
3?
is, my lord, 3 volumes.
3. Then you have all the 3 volumes of the writ petition. Only the cans will be supplied to you. Also, serve all the cans. Call the next matter, please.
Let's take respondents. I'm appearing for the writ petitioner, my lord. The affidavit of service.
What is the matter?
My lord, this is a matter, my lord, where the petitioner is the mother of a mentally ill person, my lord, and the lady was assessed as 75% disability, my lord. That is at page 11.
There are 2 petitioners.
There are 2 petitioners. Petition number 1 is mother and petition number 2 is brother.
Brother?
Yes.
All right.
And my lord, actually, my lord, they are seeking the administration of the, actually there is a joint property and the particular girl is the co-sharer of the particular property, my lord. I have annexed the deed and seeking to administer the particular property for the benefit of the particular mentally ill person, my lord. That is, my lord, disability recommended sheet will appear from page 11. Disability name, my lord, got it?
Yes, disability
Disability name
recommended.
ID from birth, brain and mind, and therefore disability percentage is 75%, disability condition not like to improve, disability not necessary or not needed to be assessed. Escort needed. So mother is the natural guardian of the particular girl, my lord, the mentally ill person, and
the girl is aged 33 years.
Yes.
And only in August 2024, you thought of obtaining this disability certificate.
No, he has a series of checking and everything. It has been issued by the member of Department of Psychiatry.
Whoever has issued it, are there any documents prior to this?
Document
All on a sudden, only for the purpose of administration of the property,
My lord,
You are relying upon this
no,
certificate.
let me ascertain that whether they have might have been actually this cannot be acquired in a one day. It is required to be they might have assessed, my lord, in earlier occasion. Yes,
What do you want the writ court to do?
My lord, give me a liberty to file the supplementary affidavit.
No, what do you want the writ court to do over here?
Yes. My lord, first of all, board is not medical healthcare board has not been constituted. If the medical healthcare board has been constituted under the Medical Healthcare Act, my lord, this is 2017.
Lord, it has to be referred to the board, and board would constitute a committee.
Yes,
is the board
yes,
there?
everyone knows that board can constitute the committee and all.
Is the board functional?
Yes,
Does the
has
board
not been
exist?
functional, my lord. This is
So let me take instruction whether the board is functional
Yes.
or not.
Give me that provision.
হসপিটাল দিয়েছে হসপিটাল দিয়েছে
মেডিকেল বোর্ড না এটা আলাদা বোর্ড
এটা আলাদা বোর্ড আলাদা ওয়েলফেয়ার বোর্ড
আন্ডার সেকশন 80 মানে there's a
And my lord, under section 14 of the act, 14 appointment and revocation of the nominated representative. Actually, under this act, there is no provision for appointment of guardian.
Where is the provision for this constitution of the board?
Section 80, if your lordship takes it, your lordship has the
80. Proceedings before the mental health review boards, constitution 73.
and the chairperson with the district judge.
73.
Yes, I am not disputing to that, but board has not been constituted as yet.
That is his prayer for constitution of the board. This much the writ court can do, nothing beyond that.
No, my lord, being the parent party, my lord, this court can also examine that whether constitution of board, my lord, the board is not functioning, my lord. The proceeding is board is
The petitioner alleges that the mental health review board, in terms of section
my lord, that
70
is not my prayer. My prayer is to administer the property of the mentally ill person, and she is unable to perform his regular course.
At the same time, this is your prayer. The writ court cannot give you any liberty
Yes.
to administer his or her properties. This the writ court cannot do.
My lord, I am showing,
Right.
my lord, there is a judgment from the Kerala bench, my lord, division bench, my lord, and there are also the, my lord, the Allahabad bench judgment, which also, my lord, observed that this, my lord, I am showing those judgments.
Tell me one thing.
That is a different.
The lady is there in existence for 33 years.
Yes.
And the property is also there.
Yes.
What were the mother and the brother doing
My lord,
for so many years?
This is in the year of, my lord, that is September 2024.
Whether there are other legal layers also, because they might take the responsibility.
Yes.
My lord, only, my lord, September 2024, my lord, this is assessed finally, my lord, and this has not been, it is
Finally assessed.
Yes.
When was it initially detected?
My lord, initially I shall submit these prescriptions and all. It is
You have not submitted with the writ petition.
Disability is from birth. He has already annexed, my lord.
I have seen that. You have not annexed any document to show that the property was not.
Chance may be given, my lord, the petitioner to show the bona fide. My lord is only that is, my lord, that this is the only piece of paper upon which I am relying, and the, my lord, whether.
And what is the property?
The intention.
What is the property?
This is a very small property of the nearby. And this is the particular that is the property.
Description of the property?
Yes, I have given the description of the
What is it?
Schedule টা দেখ না
There is a deed annexed to the petition, my lord. Page 24, your lordship will kindly see. The top shield, my lord. Page 24.
Yes.
Is not
legitimate.
functional. For which the petitioners,
my lord,
being the mother and brother of the mentally disabled girl child, are not in a position to administer the property. Stuff. Next. The petitioner relies upon a certificate, no, not certificate, a disability recommendation sheet
দেখি না অর্ডারটা
dated 5th August 2024, issued by a member of the Department of Psychiatry, RG Kar Medical College and Hospital, Kolkata, wherein it has been mentioned that the girl is intellectually disabled and the affected part of the body is the brain and the mind, and the disability period is from birth. Stop paragraph. The percentage of disability is 75%, and the condition is not likely to improve, and the girl requires an escort. Stop paragraph. Learned advocate representing the state respondents seeks time to take instruction as to whether the state has notified regarding the constitution of the Medical Health Review Board. Stop. Learned advocate for the petitioner seeks time to file supplementary affidavit annexing documents in support of the submission that the assessment of the health of the girl was done long back, not assessment, was not done, initiated long back, and final assessment was made only in August 2024. Stop. Leave granted to the petitioners to file supplementary affidavit annexing all documents in support of assessment of the medical health of the girl, by
my lord,
17th.
By 17th.
Advance copy should be served up.
Yes.
With an advance copy to be
Yes,
served
sure.
on the learned counsel representing the state respondents. Stop. List the matter on 28th of January 2025. Stop. The state shall take necessary instruction in the
Under the
meantime.
same heading, my lord.
Affidavit of service is taken on record. Urgent motion.
Grateful.
Last occasion, you was directed the financial company to take instruction as regards to payment made by me and whether they have followed the procedure prescribed by the RBI in its guideline. That report they are yet to forward me. That a copy din. Yes.
Yes.
The report.
Copy. Did you disclose the steps taken to seize the vehicle?
Yes, ma'am.
Everything is there?
Everything, ma'am. Everything.
You go through it and come back? State?
Can I take it about 2 p.m. let? I'll be ready by 2 p.m.
No, you take instructions. The report filed by the respondent number 3 in court today is taken on record. Stop. Copy of the same served upon the learned advocate representing the petitioner in court today. Stop. List on 7th.
Except
Tuesday.
7th.
8th.
8th. At same position. Millet.
Yes, same position. Urgent motion the other one.
I beg to appear on behalf of the petitioner. My lord, kindly recalls, my lord, this is a matter with regard to the order which was passed on 23rd of December, my lord, with regard to Drugs and Cosmetics Act. My lord will kindly remember on that very day, it was submitted by the union that no arrest should be made. Now, what has transpired during the interregnum period on 30th of December, my lord, it will shock the conscience of the court. My lord will kindly see order ta dao amake. But there was an order of 19th of December 2024, which was not brought to the notice of this court. We were not obviously aware of the case because no case details were given to us. It was a complaint case filed under section 200 of the CRPC by the inspector, which has been kept for taking cognizance on 1st of April 2024. My lord, there was an order to that extent of 19th of December. I'm just handing over a copy because I have just received the copy. My lord will kindly see. It reads as one petition of complaint alleging or offense under so and so of drugs and cosmetics is filed against the above noted accused. As it transpires from the case record that the complainant is a public servant acting or purporting to act in the discharge of his official duties, it is not necessary to examine him. The personal attendance of the complainant is dispensed with under section so and so. Certain documents so and so have also been filed. Let this copy be kept on record. Peruse the documents which are filed today. Heard the learned counsel representing the CDSCO, registered the case as complaint case, fixed 1/4/2024 for hearing on the point of taking cognizance, issue notice upon the prospective accused. Well, this was not known to us. When everything was going, well, on the 17th, they started reading, nothing was communicated to us. Now, my lord, on 30th, thereafter, my lord, on 23rd, we came before your lordship. Your lordship has directed us to go and appear before the authority with the relevant documents. We appeared. There was also a direction under paragraph 10 of your lordship's order, which starts as internal page 2, the last paragraph of your lordship's order. My lord, there's a second sentence in the next page, my lord, top. In the event any further document is required, that should be communicated. My lord, that was communicated. We went, we said that we will communicate the further records. On that day, we were asked to wait and we were taken into custody on that very day. On 30th, we were taken on custody. Now, my lord, this entire process is done in a pre-cognizant state when the learned magistrate also did not take cognizance of the situation. Well, thereafter, my lord, I was sent to judicial custody for 3 days. I was there on 3 days. My lord, yesterday I mentioned the matter before your lordship. Consequently, subsequently, we also had appeared before the learned ACJM, and the ACJM was pleased to, he was shocked. I'm so sorry, my lord, CJM, Alipur. He was shocked to see the situation, and he immediately directed to release the person, the petitioner. Obviously, no bail was required. Now, my lord, the situation today is this, my lord, that on 23rd, this honorable court was misled. This honorable court was misled by making submissions that the petitioner will not be arrested.
No,
there was
this
a
was not the submission.
my lord, it is that is there on the video. Now, thereafter, my lord, this entire process which has been initiated, my lord, that is subject to the case which is registered under section 200 of the CRPC. Now, in that case, my lord, the entire procedure which has been adopted by the inspector is absolutely alien to law. Because this process which is going on, that can be only done when the cognizance is taken on April by the learned magistrate. So, my lord, this is very shocking that also on the date when 30th, when the petitioner was produced for before the learned ACJM, my lord, the CJM was not on his in his seat.
Anyway, now what is to be done today?
My lord, what I am praying for is today that this entire proceeding should be quashed until the magistrate takes cognizance, because there is no requirement, there is no procedure of law which has been followed. My lord, it is under the act, it is the inspector is to act in accordance with the provisions of CRPC and the provisions in the Drugs and Cosmetics Act. So, my lord, when it is now, it is happening double jeopardy. My lord, they are going against 200 also, and they are also proceeding against me in a procedural manner, which is completely colorable exercise of power, which is unknown to law.
Very well.
My lord, one thing I am praying, my lord, strict actions may be taken against, my lord, some punitive actions may be taken against the inspector, my lord. This is absurd, my lord. This is, I'm falling short of words to explain myself.
Yes.
Yes, my lord. The petitioner is manufacturing spurious drugs. This complaint has been received.
Very well. I want an affidavit from your end.
Yes, my lord. Without affidavit, this cannot. It requires affidavit.
Very well. On the last occasion also, it was submitted that affidavit is required, instruction is required. The petitioner was directed to submit documents if required. Did you intimate the petitioner that these are the documents which are wanting? You tell her to come to the police station and you arrest her.
My lord, this is a wrong submission again.
Please,
My lord, kindly seize
lord,
this.
not interrupt.
My lord, kindly seize
My lord,
this.
before your petitioner, the respondent authority, they were making search and seizure. Many documents were not available with the petitioner. It was paid before your lordship. Some more time is required. Your lordship granted 2 days time to produce those documents to the respondent authority. They waited till 30th. That date also they could not produce. And these drugs are highly valuable drugs for cancer.
I understand the petitioner may have committed certain illegalities according to you, right? But there is a procedure of law which is required to be adopted. You just cannot go and put her behind bars.
Are they trying to run a trial here, my lord? Then I'm ready for it.
Please come.
Purchase bill, they could not produce.
Learned advocate representing the petitioner submits that the petitioner was directed to appear before the authority on 30th of December 2024, and when the petitioner visited the office of the inspector.
Yes.
Which office? Which office? From where was she arrested?
My lord, Nizam Palace, there's a CDSCO office at 7th floor.
In the office of the CDSCO, she was arrested and taken in custody. Stop. Next. She was released by the order of the learned magistrate.
Yes, my lord. CJ.
On 2nd January 2025. Stop paragraph. It has been submitted that the authority are adopting procedures alien to law to harass the petitioner. Stop. The petitioner has come to learn that a complaint case being number 3722 of 2024 was filed and the same is pending in the court of the Chief Judicial Magistrate, Alipur. Stop. The date for taking cognizance in the court of the learned magistrate is 1st April 2025. Stop. Next. The learned advocate representing the Union of India submits that the petitioner is manufacturing spurious drugs and action has been taken against her in accordance with law. Stop paragraph. Let affidavit in opposition be prepared and served. How soon?
At least 4 weeks time late. Make it 3 weeks.
By 24th of January 2025. Reply, if any, by 7th February 2025. Stop. The liberty to mention the matter for hearing before any bench having determination. Stop. Paragraph. The respondent authorities, it will be open for the respondent authorities to direct or require from the petitioner any document that may be wanting upon giving proper notice.
My lord, may I just indicate two more things, my lord. Lord, one thing, my lord, it is not date for taking cognizance, it's for hearing whether the magistrate will take cognizance or
My lord, for that purpose.
And another thing, my lord, since the complaint case is pending before the magistrate, my lord, this entire procedure which has been adopted by the inspector by now, that shall be stayed, my lord, because otherwise there will be a double jeopardy. And third thing, my lord, I am praying, my lord, I am praying.
The matter before the magistrate is April.
My lord, I know.
We are keeping it sometimes in February. The dates will be over and you can mention it for hearing before any bench. I am not restricting it to this bench because this bench is overburdened. There are hearing benches. You can try out over there to get it heard
My lord, the
prior to
harassment
April.
will continue, my lord, where your lordship has seen the harassment. That will continue.
I have directed them to give you proper notice if they require some documents from you.
My lord, one more
Yes,
thing.
that will be done, my lord.
Praying for some, my lord, measures and punishment.
At the time of final hearing, how can it be done at this stage?
Let them also file an affidavit to the extent of their conduct on 30th of December. How did they do this? Let them also
disclose everything in their affidavit. If it is
yes,
not disclosed,
because that is not a point in the writ petition. That is
even the
Your lordship was pleased
if
to
your lordship
extend
will
some time to
clarify
the
that
petitioner for producing the documents.
And
But
my
the
lord,
petitioner failed.
if that be kindly clarified that they are also to file an affidavit to that extent also. And my lord,
the affidavit shall disclose the documents relying upon which the petitioner was taken in custody on 30th of December 2024.
and my lord, not to take any coercive steps, my lord. Not to take any coercive steps. In the meantime, they have already, my lord, has shown this code they can. Well, I'm really apprehensive, my lord, because I was apprehensive, your lordship.
Are you apprehensive of further arrest?
Yes, my lord. They can do it, my lord. We were before your lordship. Your lordship was pleased to make the matter returnable on 2nd.
Yes.
They said they will not arrest, and then they go and arrest. My lord, now I have shown, my lord, this is beyond the procedure of law. My lord knows Anish Kumar, Satinder Kumar until, my lord, the Supreme Court has issued guidelines. Everything has been flouted. My lord, some protection.
Your lordship extended.
Not to take any coercive steps,
The
my lord.
respondent authority granted them 5
The
days time.
allegation is manufacture of spurious
My lord,
drugs.
yes, my lord, and there,
Those are
my lord, no, my lord,
drugs,
my lord, I will tell you, lordship, what has
Most
happened.
seriously
Here they said we are labeling. That's how manufacturing. There they went and said we are manufacturing spurious drugs.
That will be.
My lord, now the two things are separate. If we are manufacturing drugs which are counterfeit drugs, my lord, it is upon the concerned companies to come before. Anyway, nonetheless, my lord, let my learned senior friend show.
Liberty to mention.
Hello,
If there is any difficulty, liberty to mention is there.
Yes. My lord, respondent will file every.
Say something in court and in the affidavit it will not be there. I remember distinctly it was mentioned that no arrest will be taken.
My lord, on
the
that
matter was made returnable on the very first day.
My lord,
and now the submission is that the lady was taken in custody. Why will this type of action?
3 days he was in judicial custody.
She will be in
3 days.
judicial custody. Wait.
And the
my lord, led by Mr. Vishwabrata Basu Maulik, my lord.
Where is Mr. Basu Maulik?
Mr. Basu Maulik is, my lord.
Nowhere to be seen, neither virtually nor physically. It's your name that will go down.
I'm so grateful.